Adjournment request, if any, from item number 1 to 8. From item number 9 to 19.
Your Lordship, may I submit something?
Yeah.
I'm the appellant of W8297 of 2021.
Yeah.
So I would like to mention for early hearing.
Is it listed today or?
No,
you
it
won't
was
get
listed
it
on
listed.
20th, but it was adjourned
When it was listed last
on 20th of June.
20th. In that first week, August first week. August first week. You send your requisition.
May it please, my lords, I beg to mention item number 12, my lords. I appear for the respondents, my lords. I'm seeking some time, a week's time to file my objections to the delay application, my lords. If the matter can be taken up after a week, my lord.
You are required to.
Yes, my lords.
file an affidavit.
Yes, my lords. To the delay application, my lords. We are supposed to file our objections
Urgent. Here.
after 1 week, my lords. Deeply obliged.
May I please? Well, I have to mention item number 23. 23, Lordship. 23. Okay, for Patwa Kota Delhi.
Urgent.
Lordship. Lordship.
I beg to mention item number 21, Lordship.
Yeah.
Maybe taken up on day after tomorrow, Lordship. Today I have some difficulty,
Day after tomorrow, then next week.
my lord.
May it please, your lordship. Also, with the consent of the other side, I beg to mention item number 35, lordship.
35.
I'm for the respondent, lordship.
Yeah.
Let this matter be adjourned today and taken up next week, lordship.
Lordship may take it up on next week, your lordship, on 25th, your lordship. We have some urgency.
May not be this bench is available next week. 2 weeks. 2 weeks.
Lordship.
Obliged, lordship.
May I please, your Lordship? Lordship, I beg to mention item number 33 minutes. I'm for the respondents, my lord. I need 2 weeks minutes to file a response, my lord, to get updated instruction. Consent has been obtained, my lord.
Urgent.
Lordship.
May I please, lordship? Lordship, with the consent of the respondents, lordship, I beg to mention item number 28, lordship.
Yeah.
Lordship, my senior is out of station, lordship.
Urgent.
Lordship, lordship, this matter may fix after, lordship, after second week, lordship. Order fifth, it can be fixed on 6th, lordship.
After second week.
Humbly obliged, lordship.
Any other request?
May it please, your lordship, I pray for listing of a writ appeal, my lord. Lord, the matter was, my lord, the last judgment was passed on 4/6/2021. We had filed it in the last week of this vacation.
Next week.
But can it be on Monday, my lord, if I may pray?
Next week.
Highly obliged.
Yes.
Daily list for orders item 1.
Road is operational now.
Yes, my lord. The road is operational, vehicles are flying. Only thing, my lord, remains the repairing of the wall, my lord, boundary wall. My instruction, lordship, again, some disturbance again from the public. They are taking police help. They will do it. My lord, 15-meter, ultimately I'm told that 15-meter wall has to be constructed. Bouldering, then pillar, then wall. That entire.
What about the encroachments over the land?
No, there is no encroachment over the land. The wall is not situated over any patta land.
Over the boundary.
Over the boundary, it is there. The circle officer has already demarcated the land. It is demarcated, and my lord, they said the process will take 20 days time. The bouldering, pillar, and wall, and then it will be there. I'm sorry, my lord, I have only one copy, my lord. This is regarding. This is the second report is regarding the plying of vehicles and completion of the road. And the first,
This vehicle
Yes.
smoothly,
pictures are there, pictures are there.
pictures are there.
Yes, sir. I pray for legitimate take up. Yeah. That's it.
Yes,
Our main issue is the boundary wall, closing of that opening portion of the boundary wall.
saying that the demarcation has already take place and they'll construct the boundary wall.
But they haven't done it, my lord. Let
Yeah.
them, they haven't done it yet. Almost 15 days have passed
There's some-
after construction of
There
the.
is some objection on the local residents, again, as they have raised objections regarding construction of the road. They'll do it. Dispose it.
Can we wait for one date, my lord? Let them do it, my lord.
Yes, yes,
Otherwise-
I am praying for giving us 3 weeks time. They said 20 days time, they will complete it. With police protection, let me take up after 3 weeks, Lord. We'll update the position.
Because our main issue is that all this exercise has been done only for that purpose, my lord.
That's right. Okay. Then council, Mr. Dinath had submitted that after completion of the construction of the alternative road, the vehicles, the same is made, completion of the alternative road, the same is made operational. And the vehicles are flying smoothly. Full stop. This further submitted that so far is regarding the construction of the boundary wall is boundary wall of the land belonging to the High Court. It's land belonging.
Yes,
belonging to the High Court is concerned. The same would be completed within a period of 20 days. Stop. List this matter on 8th of August 2024. On that day, Mr. Nath will submit the actual report regarding the completion of the construction of boundary wall of the land concerned.
Item number 2.
Yeah, please, Your Lordship. Lordship, in this matter, I was required to take justice service, Lordship. I have taken, Lordship, may I be pleased to see the Lozima order dated 26/6, Lordship.
The service is already complete.
Yes, Lordship.
Is anybody is appearing?
I can do one thing, Lordship, the previous council was there in the CAT, I can inform him.
Yeah, as per the report of the Lauzima court dated 26th of June 2024, the service upon the sole respondent that been duly affected. Stop. Is this duly affected? However, none is appearing on behalf of the respondent, sole respondent. This matter for admission after 2 weeks. In the meantime, you may inform that advocate. Counselor, yeah.
Item 3.
May I please your lordship? Staff pattern of consumer, state consumer has been.
There was a
made,
recommendation
lordship.
pending with the state government.
Yes, lordship, already 13 numbers of
Posts.
persons, yes, lordship, they have deputed around 7% also. Therefore, total number is now 13. Lord.
But they basically put some stuff from the food and civil supplies on deputation. So as far as the state is concerned, these 13 posts are now filled up. And as of now, there is no such immediate crisis of manpower, though other amenities might be required. So more or less, my lord, substantially, my lord, the difficulties are, my lord, solved as of now.
Most of the difficulties are already over now.
My lord.
Now, what remains? Now, what further infrastructure is required for the purpose of this smooth functioning of consumer redressal forum, state consumer dispute redressal commission?
My lord, the issue is relating to, my lord, actually a bigger building, my lord, than a bigger courtroom. But then that is something, my lord, probably that we cannot probably go in at this stage. The state would, of course, take a call, my lord, in the long run on that. But then this PIL was basically filed because at that point of time, there was not even a sheet of paper to pass an order. That was the state. So substantially, it has been redressed, my lord.
Okay, alternate counsel. Ms. R.D. Bora, the government advocate, has submitted that pursuant to the request made by the commission, the Director Food and Supply, Consumer Affairs, Assam, has already deputed 13 number of grade 1, grade 2nd, grade 3rd, and grade post personnels in the commission. Stop. An affidavit of respect is filed on behalf of the Secretary to the Government of Assam, Public Distribution and Consumer Affairs Department. You have already filed this affidavit,
Lordship, today, lordship.
which is taken on record. Full stop. Para. This BIL essentially filed by the petitioner raising a grievance regarding the lack of infrastructure and facilities in the Assam State Consumer Dispute Redressal Commission. Full stop. Pursuant to the orders passed by this court from time to time, some stressed infrastructure has been made available in the commission for the smooth functioning of the same. Would stop. Learned counsel to the petitioner has frankly submitted that by and large, the infrastructure facilities have been improved and on account of the same, the commission can function smoothly. Full stop. He has submitted that so far as regarding a new building of the commission is a new building with big court, big courts and other facilities are concerned. The state government is required to take into consideration of the same. Stop. Since the state government has provided infrastructure and facilities for the smooth functioning of the commission. We are of the view that no further order is required to be passed in this petition at this stage. However, the state government would also take into consideration regarding allotment of a suitable land for the purpose of construction of a new building of commission in the due course of time with big courts and other facilities for the litigants as well as the court staff. Full stop. We hope and trust that the state government shall take steps for the same in near future at the earliest. With these observations, this PIL is disposed.
Item 4.
May please, your Lordship. Lordship, with apology, Lordship, item number 33 was taken adjournment in the morning by the respondent side. Lordship, there was an interim till today. I am for the appellant, Lordship. Lordship, may,
So the motor is operating.
yes, Lordship, it was till today. Adjournment
32 or 33.
33, Lordship.
Interim order if I need to continue till.
Obliged.
Item 4.
Hello, I am for the response number 3, madam. Yesterday we have filed affidavit. Yesterday we have filed affidavit, which is not.
You have filed the affidavit?
Yes, Lordship.
What is that?
Yesterday filed by law, not on in the record.
It is not on record.
Yes, Lordship.
But they have to take my lord, decision, my lord, regarding survey. But they have, from the affidavit, my lord, then it is clear that, my lord, they yet to, my lord, yet to make that survey, my lord. From para 5 of the
Missing autonomous.
machine autonomous council, my lord.
Yes.
Affidavit come on record.
From affidavit, they have a copy as a billion.
And counsel, Mr. D. Gogoi, appearing for the missing autonomous council has submitted that. An affidavit pursuant to the order passed by this court has already been filed.
19th.
Has been filed on 16th of July 2024 only. Office to take the same and list this matter after the.
My lord.
Hello, Lordship.
Item number 5.
With the Lordship. My lord, in this case, my lord, as per the last order of this honorable court, my lord, I have taken justice service, my lord. Still then no response from the respondent, my lord.
No, you have not taken any justice service.
Yes, my lord, it was taken on, my
No
lord.
steps have been taken till date. 15/5/2024 is the report from the court. Office report is there. No steps have been 27/6/2024. Till date, you have not taken any steps for service of notice upon respondent number 10 and 11.
My lord, this is 23, my lord, in 23, my lord, they have taken justice service, my lord, I have taken.
20?
My lord, as per order of this honorable court dated 23/1/2023.
123, there is no order of 23/1/23, sir. There is an application seeking leave to file appeal. Which matter you are appealing, mister?
My lord, this is Sipur, my lord, this is Sipur Venture LP.
Yes. But this IA number 2886, 2886.
2886.
On 5/4/2024.
Yes.
This was the order of the court as per the office report. No step for service of notice upon respondent at 10 and 11 has been initiated. And office report says that you have not taken any steps for that.
My lord, then my lord, a short date may be given, my lord.
And what is the, by the way, What is the order which you want to challenge by way of appeal?
My lord, in this order, my lord, basic facts of the game, basic fact of the case, my lord, during the pendency of a civil suit, my lord.
Understand, sir. But what order the learned single judge has passed?
Single judge says, my lord, the school headed by,
Directed the commissioner and secretary government shall give a due consideration to the representation
yes, my
of
lord.
the petitioner, and doing so, he shall provide the petitioner an opportunity of being so as to enable her to produce any further material. So this must have been decided by them till date.
My lord,
This is the order dated 9/5/2018.
that is the what, my
Almost
lord.
6 years have passed, sir.
Exactly, my lord. But the
Now
fact,
what remains in the challenging this order, sir?
may I submit, my lord? On the fact that there, when there is a civil suit regarding, in reference of this honorable court, civil suit to decide the matter, my lord, they obtained this order from this honorable court, my lord. This,
They obtained the order 6 years before.
yes, my lord.
And there is the direction was to decide the representation within period of 2 months. What happened to that representation? What remains in this order then?
Exactly, I have to take instruction
If
from the
that
client, my lord, latest
representation has
development.
already been decided,
Yes, my
then what remains in this, where is the question of challenging this order at this stage now? This is what the order is. Read the order.
Yes, my lord, I have seen, my. My lord, let me take the instruction from the client, latest development, what happened regarding this school matter existence, my lord. And thereafter, this court will decide.
Take your instructions by the, at 2.
Yes, ma'am.
At 2, what remains in this? Even though if we grant you permission to file an appeal, what remains in this appeal? If the order has already been executed, the representation has been
Madam, in
decided,
this,
what remains?
in this case, may I submit, my madam, friend can take the instruction from the department also, my lord,
The status is this, he had filed a writ petition, which was allowed by allowing him to go, which was directed, he went to
He filed a writ petition, civil suit, he was permitted to file in civil suit.
Yes.
Civil suit was
returned.
that section 80 provision was CPC has not been
My lord,
complied
yes.
with. Then in between, the earlier order whereby they have the state government is state, that was again revived. And
Revived.
said, okay, since it is revived, my application for provincialization should be taken into consideration. The learned single judges simply said, decide the
Decide the
representation, that's all.
That's all the report. I do not know the
What happened
grants.
to that representation, whether you have decided it or not?
There are things. There are things.
At 2.
Understood.
Obliged.
Item 6.
May plead lordship, my lord. In this, my lord, pleading is complete. Brought some serious allegation against the university authorities. And my lord, the lordship kindly come to status of the petitioner, paragraph 5 of the PL petition, my lord. He is retired professor of the Hojai College, which was upgraded to the level of university. Now he's 66 years old. And the anomaly in appointment, a person from Bengal, who is OBC in Bengal,
He was appointed on which post?
as my lord, lecturer in political science in Hojai College, Hojai University.
So in the cases of appointment of a lecturer, whether
Not
PA
only
is
that.
maintainable,
No, my lord, lordship,
PA is maintainable or
Yes.
not? In the cases of.
no, not
appointment,
not only in there. The lordship kindly come to,
This is
Mother-
the only relief you have claimed that they have appointed
No,
such persons. having
kindly
no
come to page 68, my lord.
qualification and nothing.
Page
You have
60 of the
challenged the
PIL.
appointment of the assistant professor
Yes.
and the many other posts, whether PIL is maintainable.
No, since I am not the claimant of the any post, I
Whatever
will
it may
try.
be, sir,
Yes.
in service matters, PIL is maintainable or not?
The PIL, so far my right of claim of to the service is concerned, then it's not
No,
maintainable.
no.
But animal is not
Service
only in that.
matters, if you are challenging any appointments, the Supreme Court has laid down clearly that no writ petition in service matters is maintainable.
Yes. That is
Yes,
true.
then what remains?
Yes. Now, my lord, besides, you also kindly come to page 31 first.
So first of all, you please satisfy us.
Yes, I am
regarding the
satisfied.
maintainability of the writ
Kindly
petition.
bear with me, my lord. 31.
Yes.
What
31.
is, what is happening, my lord, in the university?
We are not commenting on that, whether the university is doing right or wrong, whatever it may be. Whether this PIL is maintainable in upper metro
No.
service appointment or not.
No, his appointment is illegal, that is, PIL is not maintainable, that's
That
all.
is what you have
Not,
challenged
not
here.
only on that. If there are such anomalies in other appointments also, then
We have our serious doubt. You satisfy us that PIL is maintainable. We'll consider it. Whatever.
let it come Tuesday, my lord, for admission hearing, finally.
Not final hearing. First of all, you please satisfy us regarding the maintainability.
On
There
that,
is
your
a
lordship
question
will
of
dispose
final
of.
hearing.
On that day, your lordship will dispose of.
Then the counsel for the
And also financial anomalies and other things
Why
are there,
this
my lord, we'll
PIL
argue on that.
Just a minute, why this PIL? The petitioner has essentially challenged the appointment of certain persons on the post of assistant professor. Only assistant professor or some other post?
Some other posts also, and along with financial management.
Assistant professor, professor, and associate professor also.
And also financial,
Associate professor and assistant
Assistant.
professor in
and also, my lord,
Ravindranath Tagore University, Hojoi, Assam. Full stop. Learned counsel for the petitioner pays for and granted some time to satisfy this court regarding the maintainability of the writ petition since the petitioner because the appointment of certain persons on the post of professor.
and also financial, my lord.
Professor and assistant professor is under challenge.
My lord, in paragraph 28 also, I have financial mismanagement, that is also
Yes.
there. Financial mismanagement.
You satisfy us on the next day,
Yes, your lordship was not recorded there.
we'll consider. This on, which date would you like to have?
On any.
Next Tuesday, madam.
Next Tuesday.
Tuesday.
Next Tuesday.
Item 7.
Some of the persons have not been served.
That is one of the.
The notices on 61 to 69, 71, 72 has not been served.
Steps were taken, my lord.
You have taken the step.
My lord, I'm appearing for respondent number 62, my lord.
62.
My lord.
And what about the others? We do one thing, get the notice published in the newspaper. But otherwise, they may not come.
One in English and one in vernacular, my lord.
And yes, you are appearing for
1 to 52, madam.
1 to 1 to
1 to 52, madam.
52.
Madam.
Yes.
In the meantime, we'll file our, my lord, affidavit.
52. What about this 53, 54? These are the these persons who are running these illegal lotteries.
My lord.
As per the office report dated 15/7/2024, notice issued to the respondent number 60 returned back unserved with the postal remark insufficient address in respect of respondent number 56 to 59. The notices remain unserved. Power is filed on behalf of the respondent number 70 by one advocate. However, the notices issued to the respondent number 61 to 69 and 71, 72 remain unserved. Mr. So-and-so is appearing on behalf of the respondent number 1 to 52, whereas Mr. So-and-so is appearing on behalf of the respondent number
62.
62, 1 to 52 and 62. Full stop.
Extra copies to 11.
Yeah, since the issue raised in the writ petition is regarding the offline and online or online lottery in various districts of Assam in violation of Lotteries Regulation Act 1998 and Lottery Regulation Rules 2010. And most of the unserved respondents are the persons who are organizers of those lotteries. We deem it appropriate to direct the petitioner, direct the petitioner to get the notices of the unserved respondent served through publication. Would stop. The unserved respondents be served through publication by publishing a notice in the daily newspaper of the locality, daily newspapers of the locality, because there are several districts.
Of the state, my lord, because our main newspaper
Daily newspaper of the state having wide circulation by the next date of hearing. Put upon 2nd of September 2024. In the meantime, the respective, the respondents, the served respondents may file their response to the writ petition.
Item number 8.
May it please your lordship. So there is an office note regarding notice on respondent number 5, my lord. Can it be taken up next week, my lord? Let us try, my lord. If in the meantime it is served, my lord.
Await return of notice of respondent number 5 for 2 more weeks.
I'm appearing for 1 to 3.
Present may be marked.
Item number 9.
In this case, notice was issued and today was fixed for consideration of interim order.
Notice
Notice,
by
notice
Mr.
was take up
Devi
the,
has been
notice
received
is send the notice on
to the respondent
15th
that has been received.
and the officers are transmitted on 15th only.
Will await return of notice for
Lordship may wait because there is no option, but lordship regarding interim relief.
interim relief. The court is already subject to the service of notice upon the full respondent. Trade of interim relief would be considered on a returnable date.
Returnable date.
Subject to service.
Lordship,
Subject to service.
no, that is correct, lordship.
So
But,
get the notices served upon the sole respondent. Will consider your request for
lordship, maybe fixed next week, lord.
await return of notice of sole respondent for a week. List on so and so. Next Thursday or Friday.
25. Item 10.
May I please, your lordship?
You have taken any steps?
Lordship, yesterday we had taken steps, my lord, yet to process, my lord.
Yeah.
Yesterday we have taken steps, my lord. This, yet to
As per the
process.
office report, no steps have been taken by the by the petitioner for service of notice upon
One to
the
nine.
respondents. Learned concept for the petitioner submitted that steps have already been taken. Office to check. And the steps have been taken, let notices be issued to the respondents returnable. On. After, in the first week of August.
9 of August, 9 of August. Item 11.
My lord, this is a contempt petition, my lord. Order was not complied
What
with,
is
my
the
lord.
order?
Order, my lord, initially, my lord, page number 29 was passed by the learned singles, honorable singles, my lord.
29.
Page 29, relevant portion, my lord.
The petitioner would entitle to submit a fresh representation. For the reasons, both the petitioner to divide of and dismiss, not saying a dismissal of the petition made clear that the petitioner would be entitled to submit a detailed report of authority with the clear. If such petition is made by the petitioner shall be considered in its own merit accordance with the provisions of the law. So what is the question of?
And thereafter, my lord, page 37, writ appeal, my lord, was disposed of, my lord. Page 37, paragraph 16, down below, my lord. 37.
What is this?
Page 37, last paragraph, paragraph 16, same direction, my lord.
Case of none may be considered.
And thereafter, my lord, we submitted representation 2 times,
What
my
is the
lord.
time limit? The court has not granted any time limit to decide this representation within so and so day.
My lord.
How the contempt is made out?
My lord, the time was not mentioned, but the order was passed in 2019, my lord.
Whatever
And the
may be,
petitioner is
then
writing, my lord.
why you are silent about 5 years?
My lord, the petitioner is repeatedly visiting the office, my lord, but they are
What is
giving
that,
only
sir?
assurance, my lord.
That is
Only assurance.
strictly saying, sir, it is not a contempt. Willful disobedience. How can you say it is a willful disobedience?
First representation filed, my lord, lordship may kindly see page number 39 initially, and thereafter recently another application filed, my lord, page number 41.
That's There's nothing, sir.
My lord, may I pray, my lord, may I pray one observation that, my lord, my case may be considered, my lord, in accordance with.
And then you will come again with this.
Otherwise,
This
my
is
lord,
the
the
observation is there
petitioner-
and they have not complied again, contempt petition.
My lord, the petitioner
Sir,
is having,
contempt, strictly speaking,
having no way.
contempt, then you can't do.
Otherwise, my lord, the petitioner is no way, my lord, to get the remedy, my
Who
lord.
is appearing for the elementary education?
My lord,
Which council is appearing for elementary education?
elementary.
Elementary education.
I appear for the department.
What happened? The court has, though the court has dismissed the writ petition, but issued a direction to decide his representation. Why you not decided his representation?
Last page. Dispose.
Lordship will have it next week. I'll find out the status. Should be there, madam. Should have been.
Friday. Take instructions. We are not passing any order. Take instruction.
I'll.
Friday. Give the copy of.
Item 14.
May I please your lordship? I have for today is for reply from the Rex for number 6.
Instead, interrogatory application. What is this application is? What is this application is?
The petitioner, when he was suspended, had approached this honorable court in the writ petition, challenging the suspension order. During the pendency of the writ petition, a penalty was imposed upon him. He was earlier working as the in-charge headmaster. The penalty was stoppage of one increment without cumulative effect. And he was removed from the in-charge and the next person was given the in-charge of the headmaster. Well, he has approached this honorable court against that order of the learned single judge, and in this IA, he has prayed that he should not be directed to hand over all the documents to the now in-charge principal. That would render the entire
Writ
school.
petition is still pending.
The writ appeal is pending, my lord.
Appeal, writ was dismissed.
It was closed because the punishment was imposed upon him. The suspension order had no value.
Initially, the writ was for against the suspension.
Suspension order, my lord.
And disciplinary inquiry, some punishment was imposed.
Yes, my lord.
And pursuant to that,
He should have challenged the discipline proceeding at best. But saying that I will not hand over papers is difficult.
Challenge the single judge bench order challenge. I have challenged. Which was my my post is reinstated as a assistant teacher. But my prayer is that I need as a IC headmaster.
this give there.
Yes.
May I please receive it? Respondent was changed again, issue a so-called notice.
That is page 78 is the order of the learned single judge.
Yes.
Also, disciplinary proceeding already pending. In that time, the department punished him.
So now you have to hand over the charge. You were suspended on 16th of June 2023, and till date you have not handed over the charge. You have to.
I have challenged this order, my lordship.
Why? How can you challenge this order? File a separate writ petition. You have not challenged this order in the writ petition. In the writ petition or the appeal, you have not challenged this order 7/5/2024, or now you are seeking that this order be stayed. It can't be done.
My lordship, can he say next date For my seniors have medical urgency. So
Yeah.
medical urgency, my senior. He
What
said
the
next
senior
day.
do, the fact will remain same. What
My
the
senior will be
do
appear.
here?
My senior will be appear.
Okay, you ask your senior that despite your request, the court has passed on. You inform him. This IA number so and so is preferred on behalf of the applicant with a prayer to set aside and quash the order dated 7/5/2024 passed by the Block Elementary Education Officer Rupahi, Nagaon, Assam, Bajigaon, whereby the petitioner whereby the applicant is instructed to hand over all relevant documents of Putti Kheti MES to the in charge headmaster within 3 days. Full stop. Para. The applicant has filed writ appeal number. Applicant has filed writ petition number. What's the number of the
6853 of 2023. Read petition. 6853.
6853 of 2023, challenging his suspension from the post of assistant teacher or what?
Assistant teacher. He was an in charge headmaster.
In charge headmaster.
Substantive post was
In
assistant.
charge headmaster, but he was holding what?
Assistant teacher.
Assistant teacher who was also holding the charge of in charge headmaster in the concerned school. Full stop. During the pendency of the writ petition, disciplinary proceedings initiated against the applicant has been concluded and a punishment of stoppage of one increment with cumulative effect has also been imposed upon the applicant. Taking into consideration the above fact, the learned single judge has disposed of the writ petition number 6853/2023 while observing that since the penalty has been imposed upon the applicant and he has been reinstated as assistant teacher, he may be allowed to join in the concerned school with the said observation. The writ petition was closed. Against the same, against the order passed by the learned single judge dated 4/3/2024 in writ petition number 6853/2023, the applicant has preferred writ appeal number 119/2024, which is pending consideration. And in the said writ appeal, this application is moved, this IA is moved. Having taken into consideration the fact that the petitioner has already been removed from the post of, removed as in charge headmaster of the concerned school, we don't find any error in the letter issued, letter dated 7/5/2024, issued by the office of the Block Elementary Education Officer, Rupahi, Nagaon, Assam, Bajigaon, to instruct the petitioner to hand over the charge to the present in charge headmaster. Hence, no interference is called for. This IA is dismissed.
Item 14.
Hello, this is an application for prolongation of delay of 588 days.
588 days.
No, no.
What's the reason?
My lord, actually, my lord, the reasons are, my lord, that the appellants were pursuing remedies, my lord. Initially, we filed a writ appeal, and my lord, that writ appeal we withdrew with the liberty to file a review application. And
What happened in that review application?
after review, my lord, the review was also not entertained, my lord, but there was an observation made in the order that the review order can be only challenged in the intra-court appeal. So accordingly, my lord, this appeal has been filed.
The impugned order is dated
Now it is dated 9/9/2022. Okay.
What happened in the contempt case?
No, that is pending, my lord. That is
Pending.
pending. My lord, at page 171, paragraph 19, my lord, there is an observation by review court to page 171, my lord, paragraph 19. I will taking such.
Yes.
My lord, this appeal itself is not maintainable because, my lord.
Yeah.
Because, my lord, the first order was, my lord, order dated 9/9/22 was, my lord, a consent order. And accordingly, my lord, the earlier writ appeal was withdrawn by my learned friend, as that was sought to be dismissed on that ground, my lord. Secondly, my lord, against review also, my lord, appeal is now.
We are on the condemnation of delay.
My lord. Yeah, my lord, but
What do you want to say?
my lord, but
Condemnation of delay.
my lord, delay. If the appeal is not been, lordship may decide the merit on merit, my lord.
So we have to condone the delay for that. Yeah. The matter comes upon for consideration of the IA number. So and so, with a prayer to condone the delay of 588 days in referring the connected appeal. The net counsel for the petitioner has submitted that the learned single judge has decided the writ petition wherein the impugned order is passed on 9/9/2022, against which a writ appeal number 417/2020, against which a writ appeal was filed with a delay of 220 days. However, the division bench of this court has condoned the said delay wide order dated 16/10/2023 in IA number 1760/2023. Later on, the writ appeal number 417/2023, registered pursuant to the order passed by this court in IA number 1760/2023, was dismissed as withdrawn with liberty to the applicants to file a review petition before the learned single judge against the impugned order dated 9/9/2022. Said review petition came to be dismissed by the learned single judge wide order dated 2/4/2024, with the observation that no case for review is made out. However, if the review petitioners are aggrieved by the order passed by the learned single judge dated 9/9/2022, they have liberty to challenge the same by way of writ appeal. Learned counsel for the petitioner, applicant has submitted that in view of the above facts and circumstances of the case, the delay in filing the connected writ appeal is liable to be condoned. Learned counsel appearing for the private respondents. Because all the respondents are represented. Appearing for the respective respondents has opposed the application for condonation of the delay. Stop having heard the learned counsel of the parties. Oppose the, we have not we have not dictated that they have opposed in writing. We have simply said oppose. Oppose the application for condonation of the, having heard the learned counsel of the parties and taking consideration of the above noted facts, we deem it appropriate to condone the delay and condone the delay of 588 days in preferring the connected appeal. Hence, the IA number so and so is allowed. The delay of 588 days is condoned. Registry is directed to register the connected appeal and list it listed after admission after 3 weeks. Listed for admission after 3 weeks.
Item 15.
May I please, your lordship? President, I is for continuation of delay, lordship. There is a 119 days delay in preparing the
Why?
rate appeal, lordship.
Why?
It was happened, lordship, due to the financial hardships of the petitioner, lordship.
Huh?
Due to the financial hardships of the
What
applicant,
hardship?
lordship. It's a very poor person, lordship. He is a daily, maintaining his family by working as daily wage labor, lordship.
He's a daily wager.
Lordship.
Why? you
That
have
is
sent
why he
the
could not come to
petition?
the lordship.
Why have approached this court by way of?
Lordship, against judgment passed by the learned single judge, lordship.
Why you have approached the writ court?
Lordship.
Why the petitioner has filed the writ petition?
Lordship, it was the for consideration of the compassionate appointment, lordship.
Compassionate,
Lordship.
when your father died,
Lordship.
when?
On 1/9/2015, lordship. Father died.
9/1/2015.
15, lordship.
And till date you are surviving without the government employment.
Lordship, that is.
So what remains then? The financial hardship is over.
Lordship. Is still there living in financial hardship, lordship. Basically, silence the petition, lordship, before the learned single judge, lordship, for non-consideration of the application, lordship, for compassion appointment, with strict compliance of the norms prevailing at the time of the consideration of the application, lordship. That is the OM dated, lordship, 1/6/2015, lordship.
9/1/2015.
Lordship.
Now almost 9 years.
Lordship. If we further the petition in the year of 2023, lordship, 2023, it was decided on 24, lordship.
At the most, you can say, okay, 2050, 8 years. So how that would make any difference? That's all.
Lordship, I annexed the OM, lordship, that is the prevailing norms. Lordship, in my writ petition, lordship will find it at page 42 of my connected RTP, lordship.
Yeah.
Lordship. As per the OM, lordship, a case of the compassion appointment has to be considered up to 2 years, lordship.
Fine.
Here in this case, lordship, they considered it for only one occasion, lordship. And it was not
Your case was rejected in the year 2016
lordship.
and you have approached the court only in 2023.
23, that is true,
Why?
lordship. Lordship, it was not informed to the petitioner as per the subclause D of lordship.
What steps you have taken if he was not informed, your application was pending?
It
what
was been
steps you
approached
have
before the authority, lordship, but nothing has been furnished to the petitioner, lordship. As per subclause D of the clause 24, lordship, will have a moment, Lordship. As per subclause D of the clause 24 of the OM dated 2015, Lordship, it was the duty of the authority to communicate the outcome of the application, Lordship. Lordship, kindly have it at page 49, Lordship.
49, yeah.
Lordship. Clause D, Lordship. While disposing of the application by way of rejection, clear speaking orders shall be recorded stating the reasons of rejection, and copy of the such order shall be furnished to the applicants. Lordship. It was not done by the authority. That is why he is not aware about the pendency or a rejection of the case, Lordship. And thereafter, Lordship, in the year of 2021, Lordship, he made an application under Right to Information Act, Lordship. And in response to the RT application, Lordship, they have communicated that his case was rejected by the DLC dated 2016, Lordship. That was the 29/6/2016. That is why there was some delay, Lordship, in referring the petition, Lordship.
Some delay?
Lordship,
8 years delay.
8 years, Lordship.
What do you mean by some delay?
It was the duty of the authority to communicate the outcome of the
Yes.
application, Lordship.
That's all.
Lordship, and basically, Lordship, it was rejected on the basis of the ratio of the judgment passed by the Honorable Apex Court in the Devabhuta Tiwari, Lordship. In Devabhuta Tiwari's facts and the present facts, to some extent is different, Lordship.
First of all, you approach the court after a delay of 8 years without any sufficient explanation. Secondly, even though we may condone the delay
Lordship.
in approaching the court, but since you have family and you have survived for 8 years without there being any compassionate appointment or employment by the state government, that means the financial hardship is over.
It is not over, but also they compel me to.
Not over and
Lordship.
so it's better
It still exists, Lordship.
to set at rest this controversy here.
Lordship.
So the petitioner may not be in a false hope that I'll get the employment. He'll search for some other job. That's better. It should be came to an end here. We don't want to give a false hope to the applicant.
And the Devabhuta Tiwari's
Go
case,
for another job, search for another job or whatever it may be. Thank you. Again, this appeal would be pending for 10 years, and again he would thought that yes, I'm going to get the employment. Why to?
that is the observation of the Honorable
This
Apex
agony
Court,
should end now.
Lordship.
So, look here.
But there was a no compassionate scheme, Lordship, in the Devabhuta Tiwari's case, Lordship. Here in this case, that a particular scheme is there, Lordship. They could not consider the case of the strict adherence of the norms, Lordship, prevailing at the time of the consideration of his application, Lordship.
Oh, we have already observed this on 19/6/2024. The
1968.
Learned concept, we take some time to argue the matter on merits. On last occasion, on 19/6/2024, we have made the similar observations.
Lordship, due to some of my personal difficulties, I was not there, Lordship, on that day.
Mr. C. Deka,
Lordship, she is my colleague, Lordship.
and your colleagues, so we have heard your colleague. Why we are hearing you now? On the very same point, we have heard your colleague. Because the matter comes upon for consideration of the IN number so and so, with the prayer to condone the delay of 119 days in filing the connected appeal. Full stop on 19/6/2024. This court has observed that the learned single judge has non-suited the applicant on the ground that he has approached the court with a delay of approached the court with an inordinate delay of 8 years. This court has also noted that the learned single judge, while relying on the decision of the Honorable Supreme Court rendered in State of Bengal versus Devbrat Tiwari reported in 2023 SCC Online SC 219, has observed that delay on the part of the appellant in approaching the court disentitles him for any relief. On 19/6/2024, and concept for the applicant takes some time to argue the matter on merits. Full stop. However, the learned single, however, today, the learned concept for the applicant has failed to satisfy us that the delay in approaching the court seeking compassionate appointment was properly explained by the applicant before the writ court. Stop. And the concept of the appellant has also failed to pursue us. They failed to persuade us to take a different view, as has been taken by the learned single judge in view of the decision of the Honorable Supreme Court in Devavrat Tiwari, Supra. The fact remains that the applicant and his family has survived for a long time, that is of around 9 years, without there being any employment offered to the applicant by the state government. We are of the view that the learned single judge has not committed any illegality in dismissing the writ petition filed by the appellant. Hence, the instant IA as well as the connected appeal are dismissed.
Obliged, Lord.
Item 16.
This is a petition for conditional delay, my lord, no, 147 days. my lord.
Why delay?
My lord, we have explained, my lord,
Sir,
because
sir,
we filed an IA, my lord, before the court, my lord, for granting some time because documents are with the CBI to further transfer of them.
documents,
Documents were with the CBI and the
CBI.
Enforcement Directorate, my lord. So that petition was,
the rest of rollers roll mill,
yes,
cold storage.
yes. my lord.
Why you approach the learned single judge?
Well, we pay for some time that we can do the formality because after receipt of the documents from the CBI.
What formalities?
Well, we have to transfer amount to the regular
For extension.
for extension of some time, my lord.
1 month.
The 1 month time was granted.
For what?
My lord,
Payment of loan.
loan, my lord,
Surface
that is
matter.
a loan account, my lord,
In a written-
in the loan account, my lord.
Surface matter we are not. Yes, Mr.
Loan
You are
account.
assisting
Yes.
Mr. Sahewala, and you used to appear from the bank every time and saying that in surface matter writ petitions are not maintainable.
Your lordship, this matter is not related to surface, your lordship.
This is surface matter.
No,
You
no,
go back,
no,
but
no.
it's there.
This is
Not not surface, my lord.
No, you will not
This is a transfer.
take a step.
Yes.
You are open, you are appearing on behalf of the
No, no, your
banks
lordship,
and
this is
arguing
not a
that the
surface
writ
matter.
petition is not
This is
maintainable,
a
and now
subsidy
you are
account, your
pursuing this writ appeal.
Subsidy, my lord, that was, my lord.
Your lordship, 53 lakhs has been
Just
credited.
that we'll see to it.
Yes, sir. Page number 498 is the judgment, your lordship. Volume 2. Long pending dispute between the parties.
Later on, we have transferred the amount also, my lord.
Just a minute.
मिला कर लोन कर देगा कितनी इन्वेस्टमेंट सब्सिडी कर देगा 32,003 लाख 53 लाख तो इसको फिर बाद में 2021 में आकर निकला
तो लाइक इसके साथ इसमें थोड़ा सा मैनेजर इन्वॉल्व था बैंक, उनका मैनेजर क्या हुआ, वो प्रीफंड ऑफ कर दिया था फंड पे, तो इसका सीबीआई केस लगता है कि मैं तो पेंडिंग पेपर से सीबीआई पर लॉन्च पीरियड। मतलब सर किसी से रिलेटेड नहीं।
The learned single judges, should a direction to adjust the subsidy amount of rupees 53 lakhs against the term loan.
Well, that has been done, my lord. Only thing here, what happened, my lord, if is the respondent, he said was involved. That amount was siphoned with the position of the manager, my lord, to another corporate account. That is why, my lord. So we only say, my lord, they're taking interest.
Returnable fund, so. Notice I get under fund. Returnable loan. 3 weeks, 3 weeks. Return dates.
Item 17.
Yes.
May please lost. Lord, there's a delay in filing the appeal, my lord.
You are aggrieved by which order?
My lord, agreed by the last portion, my lord, interim order, my lord. First order, my lord, page 9 in our IA, my lord. We have also annexed in the IA.
9.
9, my lord.
Yeah.
Last portion, my lord, it is however provided that no order of appointment shall be issued to the private respondents without proper verification by the competent authorities as regards his eligibility to participate in the selection process. This was my lord, interim order, my lord.
Page number 9.
Page number 9.
In writ petition number?
In the IA, my lord.
No, this page 9 order is dated
8 to my lord. Yeah, my lord, selection of
No order of one shall be a private respondent without proper verification by the as regards to the eligibility of the participating selection process.
thereafter, my lord, matter was listed on my lord 11-4, my lord, page 11. Writ petition closed, my lord.
Yeah.
They took liberty to file appeal, statutory appeal under the rules. And my lord, it was granted, but the interim order is still holding the field. This is the observation.
But thereafter.
And thereafter, on the basis of this observation, my lord, neither my lord inquiry nor anything, my lord, I have not been appointed till date. Only because of this observation.
And what happened to that appeal?
Appeal is still pending.
Appeal is pending.
Still pending, my lord.
The appellate authority has the power to stay that order.
They have power, my lord. They are altogether, my lord, separate proceeding, my lord.
Notice of IN number so and so returnable on.
And not exactly similar cause of action, my lord. In the appeal, my lord, to have annexed one order on page 83. Exactly similar observation was, my lord, passed by the learned single judge in the said case. And it was observed that there is no bar for appointment, my lord. That observation may kindly be given. My lord.
For that purpose, we have to hear the other side. Without hearing expert order, how can we pass that order? Yes.
For admission, item 18.
May it please you, lordship. My lord, since it is a fresh PIL with a prayer for interim intervention, I think I must satisfy your lordships in this court on four things. Number one, who are the petitioners? What is their locus? Number two, what is their grievance? Is their grievance genuine? Number four, they are challenging a certain action and an order by the highway authority. Is that decision and the order is shrouded by legal infirmities also in addition to the background of the case? For that, my lord, lordship will basically to highlight all this, my lord, lordship will permit me to give the narration about the fact background, my lord, of this case.
That's right.
My lord, ever since the,
First of all, you satisfy us.
yes, I'm coming.
Your demand,
I have said four things.
just a minute.
One by.
Please let us, we want that we have some queries, and if we want that it should be satisfied, then we may make queries, or otherwise you argue the matter.
Yes. Any time, my lord, your lordship may put my query and I will hand over to my lord.
This petition, PIL petition is filed by you, raising a grievance that highway should not be constructed from that place, and it should be constructed in between a town.
Where the highway authority has already made a public commitment.
Just a minute, sir, public commitment or whatever it may be, that the highway should pass through a town and not by a other way which they have proposed to do so, where the land acquisition proceedings are already initiated. Secondly, your suggestion is that this 4-lane highway from the town is cost effective. So what is the difference between the cost and all this?
Yeah, and I'll try.
What material you have placed that if they construct the highway from other side, it would cost so and so, and if they construct the highway from this side, and it's very bizarre demand that you construct a highway from the town.
No.
So everybody is the highway nowadays, the concept of the highway is that it should be bypassed from the town.
No, my lord,
And
actually,
you are saying that it should be constructed in between the town.
because my lord, because there was a public commitment given by the highway authority.
Yes.
Since 2010, these people and the people in the surround of that township, my lord. That township is a trade and business center hub, my lord, ever since the Assam Trunk Road existed during the British days, my lord. This is the same road which was subsequently named when the National Highway Act came, my lord. It was named as National Highway 37. Now again renamed as National Highway 215. Now, my lord, these people are demanding, it is a popular stopover, my lord. Popular stopover for, my lord, all commuters and, my lord, transporters and, my lord, passengers.
Popular stop?
Yeah, stopover, my lord. Stopover. Yes.
This
Because
Jakhalbanda town.
Jakhalabanda township, my lord.
Jakhalabanda town.
Yes, my lord. In fact, the Limca's book has recognized it as a, my lord, India's day and night township. Anyway,
Maybe
that is no, I am just
now tomorrow you'll say
no.
a highway from Guwahati to Nagaon and it should pass through the Guwahati
No,
city
never,
itself.
never.
Is it possible?
Never unless
For the state government to
no,
decide.
never,
from
my
where
lord.
they have to construct the highway.
Never
You
unless
can't dictate the term, construct
no,
the highway
no,
from this place and that place.
never, my lord.
It's,
Never
uh,
ever, never
It's
ever.
very
One should
strange that
never.
the petitioners are saying that the highway should be constructed in between the town.
Why I am telling you, lord.
And it's 2-lane highway.
No.
So expand it up to 4-lane highway. And for that, that would be cost effective.
Otherwise not.
Okay, sir.
Otherwise not. But because of the peculiar factum of this case, my lord, why I am saying,
Yeah.
lords may kindly turn to page 209.
Yeah.
In the presence of Union Ministry, Minister of, my lord, National Highway Authorities and others, a decision was taken publicly. It was notified, my lord, 209 and 2010.
What is notified?
We were demanding ever since 2010 that the existing 2-lane touching Jakhalabanda and, my lord, Kumaritul going up to the National Park should be, my lord, upgraded to a 4-lane highway. That has been the demand all along. Now,
that decision was of the year.
that decision was of, my lord, 2020. It is all very recent, my lord. 10/5/2023. Lords may kindly come to
Decision.
page 209.
209.
Yes.
Yes, in a meeting under the chairmanship of so highway Kalibar shall be submitted Ministry of Road. Relevant portion. What is this relevant portion?
Yes, my lord. The next page, it is forwarded by, my lord, the team leader, 2010. This is the type copy. 2010 is the copy, my lord, is this type. It has been formally forwarded to the chief engineer Assam, PWD, by the highway authority official. My lord, in a meeting, and I may read, my lord, in a meeting under the chairmanship of so-and-so Honorable Union Minister Road Transport on 10th May 2023, in New Delhi, it was decided that the detailed project report DPR for 4-lane highway from Kaliabor to Numaligarh should be submitted to the Ministry of Road Transport Highways by consultant, the respondent number 10 and 11 companies, my lord. Meeting was attended by senior officials of all concerned departments. In the light of above, it is requested kindly to provide us the information regarding right of way allotted to existing double-lane highway, that is so existing double-lane highway, which is touching, my lord, Jakhalabanda, to enable us to prepare the proposal for additional lane acquisition required for proposed 4-lane. So there was a decision by the
Where
competent.
is the decision, sir? They have simply asked, requested to kindly provide information regarding so and so. Where is the decision?
No, my lord, in a meeting under, I think so and so, my lord, it was decided. This is the word is decided. No.
The decision.
It was decided that the detailed project, so the responsible authority
And the leaders and all, what they are objecting to it, they are making a statement that the new generation can run the country, burn the country as well. Don't force us to burn the country. So they're up to this extent that they'll burn the country for this highway.
No.
This is what you have annexed the document, Annexion 9. Newspaper cutting.
My lord,
Mainly this writ petition is based on newspaper cuttings and no material is placed.
No, my lord.
You are saying that this construction of highway would be more costly. What is the material?
No, not only cost.
What cost? What cost the central government is going to spend on the construction of the highway at the proposed whatever the proposed place?
My lord, that is
What
just
cost,
one.
is likely to take in constructing the highway from that town?
My lord. This is just one of the contentions. This is not one of the contentions. The basic contention is the somersault made by the authority. Once after this decision, Lordship may kindly turn to another page where a public hearing was given to us. Page 209, 2010, thereafter, my lord, public hearing. Come.
And what is the stage it is,
Yes.
the notification is under section
Just
58?
Lordship just see, my lord, the public hearing.
Why your objections?
No,
to the
come.
notice?
No, come. How the people has been given their commitment by the authorities all along, and how there was a somersault.
That commitment has any statutory force?
Lordship.
There is a demand, they said, will consider it. Where is the statutory force through that commitment? And in fact, there is no commitment that they'll construct the road from that side only.
My lord, then come to
It is the matter of policy. It is for the experts to decide from where the highway is to be constructed. It is not for a general public or to the board. We are not expert in that.
No, but
how can we decide whether the road should be constructed from this way and not that way?
No.
That is not the business of the courts.
Question is, my lord, after this decision, the public who are demanding, they were called for a formal meeting, my lord, by the concerned deputy commissioner of the district. Kindly come to page, my lord, 88.
Yes.
Kindly. How we people got involved? We were asked to give our, my lord,
that's right,
suggestions and all. Publics were made to be involved here, my lord. Not only, my lord, this is the public notice, my lord, at page 89. It was the 88.
Participated in that hearing.
Yes, we participated. My lord, kindly have it.
They would have considered your grievances and then they have decided.
Kindly see. I am reading page 88. My lord, let me go a bit slow. I will not take much time.
Yeah.
It is for information of general public that a public consultative meeting has been convened. That is just pursuant to the 10/5/23 decision. This meeting has been convened on 23/6/2023. It is for information that general public that a public consultative meeting has been convened for receiving suggestions and opinions, views from the public with regard to taking necessary steps, expansion, upgradation of the National Highway 37 from Koliabor to Numaligarh, that is via Jakhalabandha. New National Highway 715.
Via Jagnavalla, where is that?
I'll show.
Where is that? Sir,
I'll
you
show.
are reading something
No,
which is
it's
not there in
automatically.
this document.
Yeah, I'll show, my lord. New National Highway 75 to a 4-lane expressway. This public meeting has been convened for receiving suggestions, opinions, views from the public following a discussion with the Chief Engineer National Highways in connection with alignment report submitted by the consultant appointed PWD, Government of Assam and the Regional Office, Ministry of Road Transport and hence all willing and interested parties, stakeholders, citizens are requested to take part, and we took part in that meeting. Now, we took part in that meeting. Then what happened? In that meeting, we gave our suggestions and those were noted. Although, my lord, nothing was supplied to us. The meeting is a fact, as your lordship has seen. Now, my lord, many residents of Jagalamala, my lord, they were happy and they gave, my lord, representation to the National Highway Union Minister and also the local MPs and minister expressing their gratitude for this decision, and they requested that it may be completed in a time-bound way.
For what decision?
The upgradation of the existing 2-lane to 4-lane. Upgradation of the existing 2-lane to 4-lane.
Decision, you just show us the decision.
Yes. Now,
you show us the decision first. The gratitude part is later on. Will come later on. Show us the decision.
The page 2009 is the decision. 209 is the decision.
2009 is not at all a decision, sir.
209.
This is nothing. This is simply said, provide us the information and nothing else. It is not a decision.
209, my lord, it clearly said, in the light of above, it is requested kindly provide us the information regarding so and so to enable us to prepare the proposal. On top,
decision till it is the process of before taking any decision.
My lord, this
provide
document.
us the information, and after getting the information, they must have taken a decision.
No, my lord, this document coming under this signature of a responsible officer of the National Highway Authority.
This document, even though if read it is, where is the decision to construct the highway from that town? Where is that decision, sir?
existing is the existing means whichever township is goes through, my lord. That is the existing. The new, my lord, summer turnaround is not the existing. It is a different highway. And after that, my lord, what happened? After that, forget about these newspaper reports were in a way not relatable. Even otherwise they cannot.
Why
But
then, why you have relied
No.
upon that, sir?
because No.
You have placed it on record.
because the sudden
Repetition is based on
turnaround.
Newspaper reports
No,
mostly.
because the sudden turnaround.
Without there being any research.
Because the sudden turnaround of events, now they have not said whether this existing before making a new alignment by the same companies, respond 10 and 11, who were entrusted with the job of survey and other things, and then preparation of the DPR and submission of the DPR for and exclusively for expansion and upgradation of the existing land. Now, these newspapers highlighted that
Mr. Consul, these are the matters which the only the concerned authorities are best judged for their where to construct the highway, where to construct any building and all. This code conduct, we don't have any expertise. Simply you are saying it's a shorter route and will be cost effective without there being any material, that how much money they are going to spend on this alternate road or whatever it may be.
my lord, the concerned authorities took the decision for upgradation of 2 lane to 4 lane
You mean to say
by
that
way of a
2 lane
decision
to
making.
4 lane from a city, then for that purpose, they are not required to take land from the persons for expanding the road.
Lordship,
The road is 2 lane road at present, and if they are expanding it to up to 4 lane,
4 lane
they are required to acquire the land for the persons
in the existing.
in the existing way. And for that, there is no money is not required for that to pay the compensation and all, and to approve those persons from there.
Required.
Again, there will be objection that why you are uprooting those persons who are settled from years together.
No, but one thing.
There are so
Has
many
the
things.
question is, has they abandoned the decision to upgrade the existing law? We have a right to know, having participated in the public and invited for public hearing. Can we? Very dumb.
But in those infrastructure projects, we can't interfere lightly in these matters.
The question is, let them apprise your lordship whether the existing
Sir, why
decision.
should first you satisfy us?
No, that's right.
We'll ask them the
They have
question,
not,
first you satisfy
no,
us.
they have not given any public notification. Like initially they decided,
Sir,
they held a public meeting.
Notice is there.
They held a public meeting,
Section
apprised us.
3A notice is there.
Now, have they, my lord, abandoned the decision of upgradation of the existing 4 lane?
So where is
And
the
is it a
question
new
of-
one?
Where is the
Or-
question of abandonment when they already issued a notification for land acquisition under section 3A?
That is what we are challenging. That is what we are challenging.
What is the ground to challenge it?
Because
Simply
unlike,
because some of the persons are not interested and they are saying that road should be constructed from the in between the town, and therefore challenge.
no, the manner in which it is being done, that is
Tomorrow
important.
another petition will come and they'll say, no, sir, don't construct it from this town and construct it from that place. So how that demand can be addressed?
They, my lord, agreed to that demand and took a decision. Question is, they took a decision.
Sir, where is the decision? That's why we are asking you since
My
half an
lord-
hour, where is the decision?
My lord, more than that 209 page and communication by a responsible officer where it says that it was decided at a meeting to upgrade the existing 4 lanes. I cannot show any more document. Moreover,
Sir, they
person
simply
there
said,
too.
we have decided to upgrade and please provide us so and so information. That's all.
then inviting us for the public hearing, that also shows. That also shows something, my lord.
If they have invited you for the public hearing.
So this is
and
not
after-
done.
After hearing you took a decision, then what remains?
No, but the new alignment when made, that was, my lord, is a turnaround and no meeting, no such public was not taken into confidence, unlike the other question, my lord. Where there the decision to implement upgradation.
Simply on the basis of this PIL can't be entertained until and unless we provide some other material, sufficient material to take a call that yes, this decision is arbitrary, illegal, or whatever it may be, provide some sufficient
Now-
period. Otherwise,
now-
we are not going to.
No, my lord, the respondent number 10 and 11 company were formally entrusted to make the survey and DPR for the existing widening of the road.
Fine.
Right. They are not authorized to suggest on a new alignment, which they readily accepted. New alignment. This was not their job. It was, my lord,
Not their
absolutely
job.
clear.
It is the decision taken by the government or the authorities concerned.
And my
They are
lord,
simply the persons who prepared
No,
a
no.
project report.
And the new alignment in law also not sustainable, new alignment. Because of the last annexure given by, it goes through the wildlife corridor, my lord.
That is for the authorities to take concern. They'll have to seek permission from the wildlife authorities, forest authorities, environmental clearance, everything should be there. That is not the case. It's that on these the facts, on the basis of these facts, we have pleaded. We don't think so. Either you place some additional material to satisfy us, otherwise we are not going to entertain.
No, my lord, kindly have a look at the photograph 2013, page 213.
Photographs?
213.
Yes. What are these photographs?
So the 213 photograph, the blue and golden, that is the existing. It goes through Jaklabanda from Koritul up to my lord, the Burapahar tea estate, which is virtually before Burapahar, actually the wildlife corridors start. Now, this was what decision was taken for upgradation and entrusted to companies for, my lord, making survey, DPI and other essential works. Suddenly, my lord, the other one, the alignment has been made like this.
Which other alignment?
Yes, this is the other alignment which has been made. Number
Indicated this blue line
Yes.
is the existing highway.
Yeah,
And they are proposing to construct now this dotted line.
yes, this one.
This appears to be very reasonable, sir.
But it
You
will
go here from that town and again come here.
not necessarily, because this
Not
town shape,
necessarily, sir, it has to be necessarily, otherwise not necessarily is not the.
no. Suppose you are making two simultaneous, that is different thing. Having taken a decision to upgrade this and suddenly not telling that it has been
It's
abandoned.
very, highway should be passed through a town. It's a very strange demand. Everywhere the highways are being constructed or ring roads are being constructed to avoid the towns. Otherwise, how you will, the people would commute and how the time would be saved.
No, our, my lord, the allegation is that the sudden turnaround of the decision is also influenced by some, my lord, influential, my lord, business lobbies.
Sir, business hold, influential business hold, yes, certainly, there may be a grievance for that reason, but first satisfy us. Sir, the land which is going to be acquired are belonging to either to agriculturist or the other persons.
No, my lord, overnight the classification has been changed from agricultural to industrial.
For that, another remedy is there, sir. You can very well challenge that classification in the revenue court.
That has been done.
That has been done, then what remains then? This.
Now, just to show that what are the, my lord,
Then you
what are the extraneous considerations, my lord, guiding for sudden turnaround of the decision?
Mr. Counsel,
This
for
is
that
basically my-
reason, please, we are very frank in this, sir. We are not satisfied with the material you have placed on record to issue even notice. If you want to satisfy us or place some additional material, we can grant you.
Petition material.
That's all.
Yes, we may, my lord. These are, I believe these are the,
We are not desiring, sir. We are granting you opportunity. Desire is yours. If you want to, if you desire to place some additional documents to satisfy the court regarding maintainability of the petition or to issue the notice to the other side, we are free to, we are here to grant you the time, but not on this material.
no, at least there should be, my lord, there may be a query to the National Highway Authority and
First of all, sir,
respondents.
if we are going to satisfy, we may pass an order or we may allow the writ petition, but first of all, you please satisfy us.
And we'll have to go for some argument. Some more time we'll have to give it.
How much?
Because they are not supplying the documents, my lord. Straight away.
This,
We'll try, we will show to your lordship that these are our prayers in writing, asking for these documents. If not the documents themselves.
it is for the
No,
this writ petition is filed
give at least 4 weeks time, lordship.
by the petitioner essentially being agreed with the.
My lord, lordship, without any observation, my lord, 4
We are
weeks.
not giving any observations, sir. Or remember remember what the controversy is, we are simply.
Your lordship is asking, where is the decision? Right, formal decision.
Let us dictate the order, then you please. This PAL petition is essentially filed by the petitioners, challenging the decision of the respondent authorities in granting approval to the alignment proposed by the respondent number 10 and 11 for expansion of National Highway 715 in bracket old National Highway number 37 into a 4-lane highway from Kaliabor, Kiniali to Numaligarh via new alignment Numaligarh, full stop. The petitioners are claiming that the National Highway number 715, old National Highway in bracket old National Highway 37 be expanded on the existing highway which is passing through
Jakhalabanda.
which is passing through
Jakhalabanda
Jakhalabanda
town.
town. Full stop. It is contended by the counsel for the petitioners that the construction of the highway number 715, old National Highway number 715, old National Highway 37 on a new alignment would be more costly in comparison to expansion of the existing highway. Certain other grounds have also been raised in the writ petition. We are of the view that
My lord, that I'm sorry, that it will be more costly. That's one of the many contentions, my lord. That is not the premier contention.
okay, one of the
One of the contents,
we are of the
not the solitary content.
we are of the view that in support of the above contentions, sufficient material is not placed by the petitioners along with the writ petition. At this stage, and in concept of the petitioner face some time to produce the additional material in support of their claim raised in the earlier petition. Time paid for is granted. List on when
Minimum 4 weeks, my lord. We'll try. If they don't supply, we will go for RTI, my lord.
list after 4 weeks.
Item 19.
May it please your lordship. This appeal is preferred against an order whereby the respondents have now an order of regularization. Now, the issue herein is the present appellant, which is a central government PSU, was incorporated in the year 2002. Now, pursuant to that, we are maintaining under a social responsibility.
Persons are working from last 30 years.
That is what I'm.
The sanction post.
That it is not a sanction post. My two contentions, which I have raised before the single judge, which were also taken note of in the judgment, I'm just placing that for a reconsideration of your lordships. Number one was that this corporation, Brahmaputra Valley Fertilizer Corporation, admittedly, without any dispute by the other side also, is a new corporation which was incorporated in the year 2002. They belong to a corporation called Hindustan Fertilizer Corporation,
which because of being a sick industry was taken over by the BIFR board of the then board. And ultimately there was no rehabilitation package. It was supposed to be closed. Now the central government gave a proposal. These are all admitted facts. Gave a proposal that there is one unit of theirs in Namrup, which can be revived. And accordingly, under a condition of the BIFR, that a new company has to be incorporated. A new company was incorporated. Now that particular company is the present appellant. Now this company, there is a school therein, higher secondary school, where they are working on ad hoc basis. In fact, their initial appointment also so that it was an ad hoc basis.
Initial appointment of 40 days and they're continuing
Yes.
for last 30 years.
Lordship
That
will
is
just
the
bear
fact.
with me. Let
That
me
is the
just,
fact.
yes, Lordship. Lordship knows about the facts. I'm grateful to that. Now, what has happened is 2002, this new company came up. Now, pursuant to that, what is on record is that there has been an appointment of ad hoc in the year 2015.
Doc of
Lordship,
2015 ad hoc appointment
ad hoc appointment
of whom?
of the present respondents, the petitioners therein. I'll just place those. What they are relying on is the appointments of the year 1993 under the old company, to which I say we have no relation because this is a new company incorporated under the Companies Act, a separate company. Without
Taken over that company.
Yes.
That company you have taken over along with all the liabilities and responsibilities or whatever.
That scheme of this document I have been asking, I've not been getting that document. But then my instruction is that it is not a fact. What we had taken over is the Sikh industry.
Just satisfied that you were not supposed to take this responsibility of that school.
That
for the purpose of that. Certainly we can say. But if your proposal was made to you by the central government to take over that unit also, and in that unit if the school is there,
yes,
certainly you are supposed to take care.
School is there, but if your Lordship will see, these appointments, as Lordship has rightly pointed out, was for a structured manner, 6 months. So the records that we maintain in our company is in 2015, they were appointed and on ad hoc basis. Now, what they're relying upon is on paragraph 53 of Uma Devi, by saying that since they have worked for 10 years prior to 2006, the cutoff was 1st of April 2006. So therefore, they should be given that opportunity of regularization, which the learned single judge have said, yes, you are rightfully entitled to that. My arguments were twofold. Number one was that this company was incorporated in 2002. So even if we take them in our roles from 2002, then Uma Devi doesn't come into the picture because they do not complete that 10 years.
Their appointments will relate back to the date when they were appointed. Since you have taken over that company,
provided along with the liabilities and the assets that
you just show us that there was no liability for you to take over that school.
I was very categorical with the client also. I wanted that piece of paper, but they're not able to. Rosi will give me 2 weeks time. Because I am also not satisfied because we have that document.
That's the only thing.
And the second issue was
no liability of yours for
yes, this is what the officers tells me. This is what the officers tell me, but I have not been able to place the document.
Yes, but if the liability is there, then you have to take care.
They say it's not. Anyway, so I'll have to satisfy myself with the document, then I'll place it before Lordships. And the second argument was this is not a sanction post. They have not been working in a sanction post. And because Uma Devi categorically says it has to be against a sanction post.
Deemed, even though if you are relying on some documents that is not a sanction post, but even though if these persons are continuing since 1993, as per their claim, it would be deemed a sanction post, sir. How can we say from last 30 years they are working and it is not a sanction post?
But it has not been on record from any side that because our categorical statement in our affidavit is it was never a sanction
These
post.
are the sanction post if these persons are working from last 30 years, even though on the temporary basis.
That can be a judicial presumption coming, but
that is there. There are so many pronouncements of this. Right?
Lordship will give me 2 weeks time. I'll try to collect that document. What was taken over?
Learned concept of the appellant takes some time to satisfy this court that at the time of taking over of Hindustan
Fertilizer Corporation Limited
by the appellant company, the liability of the school run by the Hindustan Fertilizers Company Limited was not fastened upon the appellant.
Yes, sir.
rest of 2 weeks.
Item 20.
My lordship, his lordship. My lord. In the year 2023, 2024, state government for the tender for purchasing a plastic chair and perceptible in the local body center. My lord. And we participated in the tender, we were allowed to supply this. And the money has been paid. Nothing. That chapter is gone on. Thereafter, my lord, what happened? State authority again, without floating in a tender, issued 2 work orders in paper of response number 6 and 7, completely ignoring us. One, page 120.
Yes. Yes.
Page 120, my lord.
Yes.
Page 120, my lord. Sri Siddhamangalam. In favor of Sri Siddhamangalam. For this, my lord, 4 crores 95 lakhs.
Another one is 140.
Another is, my lord, 140 page. In favor of Jain trading.
Yes.
So, my lord, we challenge that the work order issued, my lord, without calling tender, my lord, about the London single judge.
So these materials have already been supplied?
Yes.
So what, we can't turn back the clock. The material has already been supplied, then what remains? Sir? Now what?
At least there should have been called, my lord. We should have been given the chance, my lord, to offer.
Sir, now that is over. In the future, if they are not the respondents fail to give you any opportunity, then we can very well challenge, sir. Now the work, this work order has already been implemented. Everything is done. What remains? We can't revert back the situation.
My lord, I have a small prayer, my lord.
Yeah.
My lord, in future, my lord, in the new open body center, if occasion arises, there must be 14 of tender, my lord. Then the purchase will be done. That instruction will be there, my lord. Otherwise, same thing will repeat. And another prayer, my lord.
We can grant you a liberty that in future, if occasions arises, you are free to approach the court.
Another prayer, my lord.
That we can do. Otherwise, we can't do this without adjudicating that they have not followed the procedure and all. For that, we have to adjudicate the matter.
Yes.
But it may take some time. But the other fact remains that the supply order is already executed.
Unless, my lord, unless there is
We can't ask them take back that supply which they have supplied and provide you an opportunity to do that.
Hearing official of punishment.
No, I have another small prayer, my lord.
Yeah.
There should be some strict order from the Honorable Court, my lord, to make an inquiry in the hearing officers, my lord, who issued the work order without the tender. Otherwise, same thing will happen, my lord.
Not even your prayer before the learned single judge.
She's there.
Huh?
Prayer is there.
If prayer is there, will repetition.
Where is that prayer, sir?
Page
66.
66.
66. Writ petition prayer. Admit this writ appeal. Yes, 66.
D, my lord.
Writ of failure respondent is saying the private.
There is no
respondent
necessary
already
in the
supply
must-
party and Mangalore mentioned in the impugned supply order. Impugned supply. Writ of maintenance. There is the inquiry and all, hearing officer. D. Issue of the debating norms without following due process.
To cause inquiry against the official.
But for that, we have to adjudicate the matter whether there is any illegality or not. Together. Having heard the learned concept of the appellant for quite some time, admit. Should notice. Mr. So-and-so are represented to so-and-so. Let notices be issued to the answered respondent. Some respondents are answered.
Hello. 1, 2, 4, 5, my lord, I am appearing.
1, 2, 5.
1, 2, 4, and 5. 3, my learned friend will appear.
3, Mr. So-and-so is appearing. Rest remaining respondents. 6, 7, 5.
So remaining private respondent, but I have one submission if Lordship allowed. But Lordship is holding page 66. Kindly come to prayer F. Prayer F. Petitioner, the appellant has indicated prayer D. Kindly come to F.
Yeah.
And alternatively, this is their alternative prayer. A writ in the nature of mandamart shall not be issued directing the respondents to provide similar supply orders to the petitioner at the approved L1 rate.
That prayer can't be granted because that opportunity was already granted to him and he has not supplied the.
My respectful submission is they cannot blow hot and cold at the same time. In prayer D, they said that cause an inquiry against the hearing official. On the other hand, they said that
simply admitting the petition, nothing. Mr. So-and-so is appearing for respondent. Let notices be issued to the remaining respondents and returnable.
Payment
10 weeks.
Payment has already been made. Everything has been done.
We have taken note of that. Despite that, if he is insisting, no, can't help.
Item 22.
By this writ appeal, my lord, I have challenged the impugned order dated 16/5/2024 passed by the learned single judge, my lord. Herein, what had happened, my lord, the present appellant who was issued license for fair price shop, my lord. Subsequently, the writ petitioner filed a writ petition challenging my license, my lord, fair price shop license before the learned single judge, my lord. Learned single judge, after hearing the matter and on perusal of the materials, my lord, set aside my license.
What are the provisions for this?
My lord, the provisions, my lord, the provisions are from Public Distribution Article Order 1982, my lord.
Where is that?
My lord, in this Public Distribution Article Order 1982, my lord, kindly take page 4, my lord. The licensing authority, my lord.
Yes.
The licensing authority means an office not below the rank of the Inspector of Food and Civil Supplies Department, appointed by the state government to the exercise on all or any powers and perform all or any of the duties of the licensing authority about different. The following the food. In respect of the present writ appeals is concerned, my lord, the page 6, my lord, serial number 16. The Deputy Director of Food and Civil Supplies, Dhubri, is the competent authority to issue the fair price shop license, my lord, and which has been issued in respect of the present appeal is concerned, my lord. Next, my lord, the procedure. Detailed procedure has not been given, but the page 7, my lord. This is the prescribed form in which the intending candidate has to be applied before the competent authority, my lord.
Now, if any family identity card be defaced, page, sorry.
Page 7, my lord. This is the
Read
form.
the provision.
Yes.
Which provision you are asking?
Well, 2J,
Form.
and the prescribed form has given is at page 35, my lord. Page 35. This is the format in which the intending candidate has to be applied before the competent authority, my lord. And the competent authority will issue the license after verification all the documents and materials, my lord. And what had happened in this case, my lord, after submission of the application by the present appellant, my lord, an inquiry was conducted by the area officer. Pursuant to that inquiry report, my lord, the license has been issued to the appellant, my lord. And in fact, my lord, the writ petitioner,
Where is the provision regarding issuance of license?
my lord, there is no detailed provision has been given in this order, my lord. And in fact, my lord,
Just who sponsor for the state? This Food and Supplies Department. Yes. Who is counsel for the state? In Food and Supplies Department. Call. What is the procedure for appointment of this fair price dealer?
My lord, in fact, my lord, in this order, my lord, there is no such specific procedure.
Is there any procedure for that?
No, my lord, simply the procedure is that the intending candidate has to be applied before
Is there
the.
any black and white? Otherwise, you mean to say that the authorities can appoint any person of their choice?
No, my lord, after apply, the inquiry has been conducted.
So where is
by
the
the area.
provision for inquiry, under what power they are conducting? the
Provision, I
inquiry?
have gone through this at order, my lord,
Huh?
but I could not found, my lord, that the.
Then what type of it is? Who is for the food and supplies department? You are. Mr. Nath, just let us know what is the procedure the authorities are following for appointment of the dealer of the fair price shop.
But it is as per provisions of the 82 orders.
The 82 order is silent about that. How you will invite the application, to whom you will give the preference. That must be a procedure.
Correct. But that otherwise, apart from 82 rules, but what is the format? What forms they are following? That I
There
can
must be
take
some notification or something, some procedure is there. Otherwise, you can't appoint any person, simply ask for this application and appoint him. It may lead to many things.
that I can apply. You know. I can obtain the instruction and I can apply.
Then in this case, my lord, writ petition did not apply also. Did not apply also.
You have not even applied and
Yes.
I applied.
No.
Lordship may kindly see,
that's why only we are strange that who applied under what procedure.
my learned friend also applied, I also applied.
His case has been recommended by some of the
Yes, Lordship.
beneficiaries. He did not apply.
No. My submission is just, Lordship, I applied before the Samavai Samiti, SS Limited. And my application was recommended to the higher authority from the Samavai Samiti. Normally, the
What is
procedure,
the authority of that committee to recommend your application? Under what provision?
yes, there is no specific provision or Lordship. Normally, the applications are made before the Samavai Samiti. And
Normally, sir, where is this normal procedure you have adopted, sir?
there is no specific provision, Lordship.
They can very well move an application before a patwari also. They appoint me this and they'll appoint him.
Lordship may kindly see the observation made by
There
Honorable
must be
Single.
some procedure, though they may not aware.
This Samavai Samiti and the fair price shop, they are in the supply chain, you know. Ultimately,
but sir,
ultimately,
who appoint the dealers?
There has
Fair
to be.
price shop, the licensee, kaise, how you will apply?
There has to be. But I'll apprise, madam. Lordship may kindly give me some time, I'll apprise.
Notice. Then counsel, Mr. So and so. Mr. Dinath is appearing on behalf of the respondent.
4 and 5.
Directed to accept notice on behalf of the respondent number 4 and 5. Mr. You.
Am I Hussein for respondent number caveat or Lordship? One.
Respondent
number 1.
So and so is appearing as caveator on behalf of the respondent number so and so. This 1, 2 and 3, Mr. Why you are not appearing for that?
The operation department, well, they have their standing counsel. In fact, in the policy, well, SC cooperation is so. GA Assam is not sure.
Leave it. Mr.
One is private respondent, possibly it's caveator.
No, one is not the private.
Phase 2.
Okay. Mr. So and so is appearing on behalf of the respondent number 1. Mr. Dinath is directed to accept notice on behalf of respondent number
4 and 5.
4 and 5. Mr. Nath may apprise this court regarding the procedure followed by the authorities concerned for appointment of dealer of fair price shop by the next date of hearing, on the next date of hearing, list on 5th of August 2024. In the meantime, the effect and operation of the impugned order shall remain in state till next date.
Lordship, the beneficiaries are not affected, Lordship. The Somavai agent is tagged, the beneficiaries are tagged with another agent, Lordship. They are getting their PDS items, Lordship. And the after the order,
Licensee, the beneficiaries are getting their PDS.
yes, Lordship, they are getting.
But let them.
Yes, and after the order was passed, Lordship, process is going on for issuing license, Lordship.
Till next date,
Yes.
they're simply saying
The
effect and operation of the order dated so and so is state, and status could be maintained in respect of
Lordship, I may be allowed to file
appointment of the fair price dealer shop.
Lordship,
concern.
I may be allowed to file objection in their IA. Till then, stay may not.
Which IA?
In their IA, Lordship. They have
May file your IA and whatever objection to the counter affidavit, where.
stay may not be there, Lordship, till then.
So for the time being, next date तक के लिए दिया, you file your objection. If we found that, we'll reject that.
Item number 5.
Yes. But I had my instructions. The appeal was disposed of by the secretary, requiring them to apply under the 2017 Act. Under the 2017 Act, when they applied and we rejected it, when nothing was done, they moved this honorable court in a writ petition. The writ petition copy, my lord, I have given the order. That was disposed of, directing the respondents to pass a order on their representation. That is WPC number 1245 of 2023.
Yeah.
Their lordship will find it at the last.
Obtaining message in such authority.
My lord. So they file a representation. On the next page, lordship will find that we had rejected their application under 2017 Act. Now they have filed a fresh writ petition, which is pending before this honorable court. That is for Sultana Ahmed.
What remains?
Nothing, my lord.
Withdraw.
Yes.
Applicant has submitted that in view of the subsequent developments, the subsequent developments, this IA has become infectious. Business is infectious.
Item 24.
Which matter may be taken up after some time, Lordship. Having granted Mr. X.K. decision late, in court number 2 late.
After the
deeply obliged.
After some time. After some time.
Item 25.
Yeah, please, Your Lordship. Well, this is similar. The petitioner had approached this honorable court on dismissal from a service pursuant to disciplinary proceeding. My lord. The dismissal order has been upheld by the honorable single judge. My lord. Our basic contention was the infraction of Rule 27C of the CRPF rules, my lord, including non-appointment of the presenting officer. And
this.
He's a constable.
By and large, there is not serious violation of any procedure.
My lord, my case is that I was not given the assistance of any defense assistant, number one.
You have not asked for that.
I have not asked because I am a constable. Actually, I was not aware of the nitty-gritties of the proceeding, my lord. And my lord, no presenting officer was also appointed.
It can't be.
My lord, what has happened, my lord, here, Lordship knows, my lord, he's a low-ranked employee, my lord. And he was, my lord, in the proceeding, my lord. In the proceeding.
Of the low-ranking
Understand, my lord. In the proceeding, my lord, he was threatened, my lord, and therefore he had to leave the proceeding in between, my lord. That is his case, my lord. And my lord, I was not given an opportunity to file written statement. And my lord, no presenting officer was also appointed, my lord. The inquiry officer acted, my lord, as the presenting officer, and my lord, even my lord asked leading questions, my lord, that I can show from the records, my lord. that vitiated the proceeding, my lord. He cannot, lord.
Having heard the concept of the parties legitimate appropriate to admit this appeal, hence admit. Yes, Mr. So-and-so is appearing on behalf of all the respondent services, therefore complete.
Obliged, deeply obliged.
IA number so-and-so, yeah, this is for the interim stay,
No, but there's a delay condition. No, there is no stay plan.
delay condition,
That was already allowed, my lord.
2086.
My lord, already allowed. No, no, stay plan.
Acha, this is, I'm sorry.
Obliged, lordships.
Item 26.
4 weeks time may be granted, my lord. Day before yesterday, I got the document from the sole respondent.
Then one of the respondent paper and it's time to file counter
Counter, yes.
after 40.
Item 27.
My pleasure, Lordship. Lordship, so a few more times can be granted for filing of the reply. 10 days. 10 days.
You are for the
Petitioner.
reply, where is the question of reply, your writ petition is here.
It's a read petition, madam. Yes. It's a read petition. I have filed our,
Fixed for hearing.
we have filed our application.
Yes, they have filed their affidavit.
Matter is, the pleadings are complete. Parties are represented to respective ones. Admit.
My lord.
Put up in reports.
Deeply obliged.
Item 29 and 30.
May it please. My lord, I have filed my reply, my lord. On yesterday, I filed my reply to the additional affidavit. So let's, my lord, this come on record on Monday, your lordship will take out some submission to be made, my lord.
Lordship, I would like to bring to the notice of your lordship regarding the maintainability of this PIL. Lordship, the PIL, the petitioners in the present PIL has already filed a writ petition in same cause of action, where they have stated that their land have been acquired, lordship.
Their
And-
land has been.
Yes, in Assam Mala, the same project, lordship. This is the judgment of the learned single judge, lordship.
No, no, that is not correct, my lord.
Proton हो जाए.
The present petitioner is the petitioner number 1 in that writ petition, lordship. Petitioner number 18, the present petitioner number 3 is the petitioner number 18 in that writ petition, lordship. Accordingly, the present petitioner number 5 in the present PIL is the petitioner number 3. Petitioner number 9 is the petitioner number 2 in that writ petition, as well as present petitioner number 8 is the petitioner number 4 in that writ petition, lordship.
Perfectly, my lord.
He is not disclosed.
No,
This was, my lord. Which one?
lordship. One more thing, lordship.
My lord, these
In-
all cases are with humble submission, my lord.
Let me
In 2022, you said disclosed.
Lordship, in paragraph number 3 of the judgment, it's been specifically stated.
Yes.
Without going into further details, considering the nature of the grievance raised,
we direct the respondent number 5, Chief Engineer PWD Department, and the respondent number 6, Executive Engineer PWD Department, Haflong, to verify from their records as to whether the land of the present petitioners would also be included in the construction of the proposed road from Haflong to Lonka Road under Assam Mala project. If the said two respondents arrive at a conclusion that the land of the petitioners would also be included in the construction of the road, necessary steps be taken to move the Deputy Commissioner Haflong or any other authority for formal taking over and acquisition of the land by following the due procedure of law. Lordship, here their basic interests are there, but in the present PIL, as per the Guwahati High Court rules, they have to file the PIL as per the rules, Lordship. It is specifically stated that while filing the PIL, as that is Guwahati High Court rules, Lordship, I am reading. A specific abutment in para number 1 of the writ petition to the effect that the writ petitioner has no personal interest in the litigation and that the petitioner is not guided by self-gain or for gain of any other person, stroke institution, stroke body, and that there is no motive other than the public interest in filing the writ petition. That has to be there. That is not been disclosed by
Everything is there, my lord,
that
my
is not
learned
been
friend
disclosed.
is.
You have disclosed this fact that you have.
Yes, yes, my lord.
In the year 2022, in your personal capacity.
No, my lord, that was initially when they went for measurement in 2022.
You approached the court with a specific contention that your land for the purpose of construction of this road is being acquired or being taken away without being acquisition.
No, no.
No, what is this, sir? This is what the judgment
My lord,
says.
I'll place on record, I'll bring on record this. This was disposed of, my lord. If your
Moreover,
lordship
Lordship,
permit, I'll bring on record.
Lordship, I would also like to bring to notice of your Lordship, in the present petition, the petitioner ages are different from the writ petition they have filed. In present petition, Lordship may kindly allow me.
Address is different.
No, age.
Age.
Oh, petition do to. 574. 574.
Here, PIL.
The petitioner number 18, that is in this one, petition Jivan Kemprai, in this 5784 of 2022, he has been stated as 37 years. And in the present PIL, his age has been stated as 45 years.
No, that may be mistake on piping. That does not.
That may be admitted, but Lordship.
Father and father is the same.
Can it be possible if this is the case in all the case, with all the petitioners? Lordship may kindly peruse petitioner number 3, that is present petitioner number 5. Soren Akzar, his age in the PIL is stated as 47 years, whereas in writ petition his age is stated to be 41 years.
Let the affidavit come on record, my lord. I'll make the submission.
Waits some time to counter to the affidavit filed on behalf of the respondent number 9.
No, I have already filed.
I have already filed. You have already filed.
Yes, yesterday I filed, ma'am. Let it come on.
And also to the affidavit that he has already filed counter to the additional affidavit filed on behalf of the respondent number 9. However, the same is not available on record. Office is directed to place the same on record. But at this stage, the concept for the respondent number 9 has raised a preliminary objection regarding the maintainability of the. It is contended that the petitioner number 1 and some other petitioners have not approached this court with clean hands and has personal interest in the litigation, and therefore, as per the rules of the Guwahati High Court in relation to the public interest petitions, this petition is not maintained. The concept for the respondent number 9 has invited attention towards the order passed by this court in WPC number 5784 of 2022 decided on 1/11/2022 and has submitted that this petition was filed by the petitioner number one along with other persons raising a grievance that the respondents in the writ petitions are constructing national highway or what?
It's a two-lane highway, two-lane
Highway,
under Assam Mala project.
Assam, under Assam Mala project. And for the same, they have acquired that, but no compensation has been given to the, given to them. Stop. It is submitted that said petition, the filing of the said petition, and it is submitted that the filing of the said petition by the petitioner number one and some other persons have not been disclosed by the petitioner number one in this petition, in this PIL petition. And it answer has also raised certain other objections regarding the maintainability of the PIL. And it counsel for the petitioner is required to satisfy the court regarding the maintainability of the petition in view of the submissions made by the counsel for the petitioner number 9.
My lord,
Learned counsel for the petitioner is how much time?
well, I'll bring on record that judgment, my lord.
Whatever it may be, bring on recording, you have to satisfy why you have not mentioned this fact.
My lord. Then your lordship will give me.
This may invite a huge cost, sir.
No, I have
We are
mentioned, my
believing
lord.
on your statements, and we are passing orders from time to time, and you have not disclosed that you have earlier approached this court.
My lord, both the
This is
issue.
your personal interest.
I take
Why
responsibility.
you have not mentioned it in the PIL petition?
Well, I will draw your lordship attention. This is there, my lord. I will draw, my lord, on next, after 2 weeks, my lord.
Then concept of the is not raised, is granted time to satisfy this court about the objections raised by the concept of the respondent number 9 regarding the maintainability of the PIL. This matter on.
Well, after 2 weeks, your lordship will fix a date, my lord.
No, you have to satisfy at the 2nd of August.
My lord.
Sorry, 5th of August.
Plus. My lord, it's there, my lord. I will draw your lordship. my lord.
Whatever it is. Yeah, you are supposed to mention all these facts.
Actually, my lord, by my reply, I brought the fraud they have committed. That's why they are now objecting.
Whatever it may be, sir. Yes, you may have raised a genuine
Yes, my lord.
cause, but
Genuine cause.
you have to approach the court with clean answer.
Yes, my lord.
Do that.
On
The
public
age has
issue, my
also
lord,
been suppressed. The age has
Yes.
also been suppressed.
public issue, my lord, I take the responsibility. This is a larger public issue involved, my lord.
Sir, whatever it may be larger public issue, then you should be very
I'll show that, my lord, from the judge.
largely clean.
Yes.
That what we are.
Lord.
Yes.
Obliged.
Item 31 and 32.
May it please your lordship. But there is a way in perhaps lordship would like to address, if I address it this way, Lord. My provincialization as a junior assistant was under challenge in WPC 1651. And I was a respondent in both. And the termination of the writ petitioner was challenged in 2428 of 16. Both the writ petitions were allowed, whatever be the grounds now. On the last occasion, what has fallen from your lordship is the age. It shows that I was gone much earlier. We have filed an affidavit placing relevant documents to show that I was within the age and correctly in the
At present,
at present, on the 2nd of August or 1st of August, I should retire. 60 I'll hit. I'm within 60 now. And in the affidavits which I had sworn in the proceedings, my age was also correctly incorporated, indicated as in the matriculation certificate, etc. Only the projection made by the writ petitioner went here and there. Anyways, now, my lord, since even if I win or lose the case, from 1st of August, I cannot be in service. Now, considering that my age was correct, if Lordship allows me the benefits from the date of dismissal till 1st and allows the other side to continue from 2nd, that perhaps could take care of it. Or I'll address on merits.
Now, what affidavit you have filed recent?
My lordship.
When is that?
This affidavit has been filed
When?
10th of June, my lord.
Of June, but what's the copy is there? So,
Should have. I got it.
no, No, affidavit on behalf of the thing deceased.
The lordship will have it day after tomorrow, my lord. We'll have it on record.
There are two appeals.
There are two appeals, one against, the two writ petitions were filed, one challenging my provincial election service, the other the termination of the writ petitioner. Both being allowed, two appeals were filed. This is on the age part, my lord. On record, Anand. Correct. 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 Then my lordship may have it on 19. In the meantime, we shall have it on record. That was on the age part, that we were within the age. Right. Right.
Who is this Khadija Begum?
My lord, myself,
Self how? कहाँ से निकाला?
my lordship.
Myself, from where we find it? Where we find it? Khadija Begum, daughter of, wife of whom? What is the address? State
Page 2.
Khadija Begum,
wife of,
So and so high school living certificate, which Khadija Begum? Which school?
Lordship, you referring to the annex.
Huh?
No, this is me, Khadija Begum.
This is me. You are saying this is me.
My lord,
Yes, okay.
if I may put it this way, my lord, as per the norms of the Board of Secondary Education,
Then you
Assam,
satisfy us that there is only one Khadija
that is
Begum.
not in dispute either, my
A
lord.
lady named Khadija, only one in the world. Then certainly.
My lordship, this document, which is issued by the Board of Secondary Education,
Secondary education, but at
but
least for
it
that
does not have,
purpose,
no, it does not have the
is
scope.
this Khadija Begum, it is you
I'm
or
coming-
somebody else.
I'm addressing your lordship on that. This document issued by the Board of Secondary Education in Assam does not have the scope to indicate other details, save and except what is there.
So where is the mark sheet?
Lord,
Is
I
there
have
school
the,
living certificate and there is nothing in the school living certificate or admit card. Mark sheet.
well, that would be towards my identity. I can surely have it. I don't know
You
what
have to
this,
show
but this is not in dispute. This document is not
the-
in,
Sir, this is the dispute. That's why only you have filed this.
then page 63 of writ appeal 355 be taken for a moment.
Yeah,
Page 63.
yeah.
The date of birth as given here, and if I correlate with page 63, the details given by the school authorities while sending the names for the provincialization, my lord,
Listen, but where is
my
the
age is
proof
verifying,
for that?
tallying with that.
Sir, you show us the certificate of the secondary examination. In you passed the examination, there must be a
All right.
and you mentioned it that you have passed it in third division at least. Where is that mark sheet?
One,
Otherwise, how can we know
anyways,
that
we'll
you
get it,
passed
sir.
third
We'll get it,
division or
we'll
first
get it.
division or second division or distinction or whatever it may be?
But, all right,
Where is the mark sheet?
but one thing comes,
Because the mark sheet have
Look.
all the details of mother and the date of birth, as well as the school also, I think so.
I can only forward whatever is the indicated in the document.
Indicated in the, but that is not
I-
convincing.
And we stand by affidavit, my lord.
Sir, this is not convincing. Even though if you affidavit, even you file some, give some facts, false facts in the affidavit, what is the mechanism?
That would be presumption to farm, my
verify
lord.
that, sir?
That would be a presumption to farm. We swear on it.
This is Khadija Begum, no doubt. Who is this Khadija?
Anyways, but one thing I must surprise your lordship. Okay, certainly we'll get that on record. But one, if I can lay my hands on that, it will be on record.
You
That
have
much
to,
is sure.
sir.
I-
If you are having this school living certificate,
Lordship, I'll
pass
get it.
certificate, certainly mark sheet should
But-
be there.
One thing I must point out, since going by my age, 1st of August,
So there are two things.
I'm out.
First of all, age, even though if you meet this criteria of age, that you were underage at that time. What about the qualification?
Qualification, since I was prior to the enforcement or enactment of the act, therefore the act does not apply to me.
Learned single judge has given another finding
Absolutely.
that you were not appointed as a junior assistant. You were
But as an
simply
assistant
asked
to
to
help.
assist your husband since he was unwell. This was your duty only, that you will assist your husband in the school duties. There was no such appointment as such.
The engagement, if I may put it the other way around,
Yeah,
of the writ appellant
there are so many ways.
was through the school authorities, prime point of time, continuing, in between the termination comes in, and the termination is supported by the education department by placing records.
1999 termination. And for the first time in the year 2016, it was revealed that her services were terminated. In between, she was working in the school, she was getting salary in the school, everything. Her name was also sent for provincialization, everything. in
My
the year
response to that
2012.
would be paragraph 17 of the judgment, my lord. My response to that, with all humility,
Paragraph number 17.
17.
Judgment of what?
of the honorable single judge.
Yeah, what?
If this view is taken, may I read?
Yeah.
Per contra, MS so-and-so, the Learned Standing Council Education, Secondary Education Department has submitted that as per the attendance register received from the Office of the Inspector of Schools, Kachar, which were in turn produced from the school, the name of the petitioner does not exist in August 1998, and therefore it could not be presumed that the petitioner was not in continuous service. It is, however, appears that no affidavit was filed. But for the fact that affidavit was not filed, but record were produced, they are supporting the contention, you know.
Whether up to 2016, this lady was getting salary, monthly salary or not?
But so far as her case is
Her
concerned,
name was sent for provincialization in the year, recommended for provincialization in the year 2012. Despite the stand of the department that her services were terminated way back in the year 2000, in 1999.
so far as the case
Everything is
projected by the writ petitioner would be on a different context altogether. I cannot have a fact-to-fact answer to that. But so far as the other part, the challenge concerned, we are on that. If Lordship considers this view that I am within the age zone and the educational qualification being prior point of time engagement, therefore, considering my Lordship takes a view in equity, then 1st of August, in equity,
Worked without any authority up to till this decision of the writ petition, that's not enough.
No, I did not hop in, but it was by the reasoned decision of the authorities in power, that I was
Authorities
allowed
has
to
taken a
continue.
decision to allow a person whose services purportedly terminated in the year 1999 to continue her till this date. And the authority, without giving any appointment, simply asking you to assist your husband, has provincialized your
So
services.
subsequently, I was brought in. I was brought in on 31st of December 1999. 31st of December 1999, that is where it is.
So first of all, you.
Sorry, terminated
Please
2nd
not
of
record this,
February.
Mark sheet.
The Lordship may consider one more pair of mind.
Yeah.
That since we'll cross 1st of August, that may not be a barrier in, otherwise it may not render the case infractious.
See, you first satisfy us.
We shall certainly, but only the 1st of August part, that much I feel.
So that will list it prior to 1st of August, you place on record that.
All right.
Why to wait for 1st of August?
I was
Why
considering
to
this
wait for 1st of August? You place on record this
identity.
along with the proof that otherwise you will say that here in the petition, this Khadija Begum, wife of so and so, father's name is not there. Along with the proof, their father's name is this. And it should be tallied with the mark sheet.
And the service record. And the
Service record, apart from that, service record, though, now we can presume how they are maintaining the service record. If a person.
No, this was the first time.
Terminated in the year 1999 and till date she is continuing. What can.
Well, I'm obliged to place it.
From these
No, I'm obliged to place it, Milord. But for the first time, after the entire contest is over, my identity would be a concern, Milord, in ways. In ways.
A person whose identity is not disclosed.
So far as the age is concerned, page 63 says by the school that I am 47 years, so and so, as on the date my name was sent. It correlates.
Sir, you pursue us to believe on the records of the school.
Oh, certainly not. I'll get a better document for that.
I think
I'll get a better document.
you pursue us to believe on the records of the school which is continuing a person whose services have been terminated purportedly in the year 1999. उस स्कूल का क्या रिकॉर्ड देखेंगे?
So far as if our Lordship takes all things correct to be correct, and I am to be wrong, then also, so far as the writ petition is concerned.
That's another thing.
Well, I'll place it the other way around.
Filed a common affidavit with the respondent headmaster. Not a separate affidavit in the writ petition.
Not to persuade a line in my favor, but to contradict the facts canvassed.
Apart from that, first of all, you have to satisfy what is your age at present. This certificate is neither here nor there. Who is this Khadija Begum?
But even if I get my one also, nothing more will be there. Only my name, roll number, etc. would be there.
Mark sheet hai?
Of course. It's there.
It's not record the mark sheet.
But may I, with all permission, I'll get it. May I place one thing with? If I'm permitted to persuade my lord a little bit further.
What?
That so far as the case of the writ petitioner is concerned regarding her termination, regardless of the fact whether that writ petition is allowed or not allowed, or even if it is allowed, then also it does not touch upon my rights. The contention was twofold and distinct and different in two writ petitions.
If this respondent was the senior, as per her, that she was senior, then admittedly her services are to be provincialized in place of you. That is there for that purpose, so we have to look into.
I'll try to get it before first. In case we could not, because it's from distant place also get it, Lordship may consider that time travel, that timeline.
That will.
Obliged,
at
wait.
the time.
Wait.
Okay, pursuant to the direction given by this court. On. Pursuant to the direction given by this court on. 22nd of May 2024. And a concept for the plan. Additional evidence. Additional evidence. Along and along with that. Two. Along with that one admit card issued by the Board of Secondary Education Assam Guwahati in the name of appellant and a school, high school leaving certificate issued by the Board of Secondary Education Assam in the name of Khadija Begum is produced. From the above documents, the identity of the person in whose name that is Khadija Begum, these certificates have been issued is not disclosed. And a concept for the appellant is granted time to the petitioner is granted time to produce the mark sheet of the Board of Secondary Education Assam issued in favor of the petitioner, mark sheets issued in favor of the petitioner, appellant in relation to the secondary examination as well as high school examination.
The same thing, one and the same.
One in the same, senior secondary.
No, I only matriculated. I could not travel further.
At that time.
At that time.
No, it was.
Affidavit to वही Board of Secondary is metric, what we call in common parlance.
There is one that's very interesting. This admit card. Khadija Begum, roll number so to the high school leaving certificate examination 1986 to be commenced on 22/4/86. And this certificate is issued on 1/8/2012.
Duplicate on the top right corner.
Huh?
It's a duplicate.
Duplicate, okay. Everything is duplicated. High school, secondary school, this secondary school examination. List on.
I'm so grateful, Mila.
List on.
After first. Sometime maybe granted, Mila, because they have such a.
12th of August.
Grateful, Mila. Obliged.
Till then, enjoy your duplication.
Item 34. Nice.
This is an appeal by the department clerkship. They file an affidavit challenging the contending that the appeal will be live before the Honorable Supreme Court.
Appeal would lie before the Honorable Supreme Court.
Under section 35N.
Yeah.
That is their contention.
So,
Lordship, we were directed to file our affidavit, but I have obtained instruction that since this is a low point, so I can argue with my learned friend is ready.
argue it out.
My lord, 14 days may be given as I'm not ready today for the argument.
Who is not present today? You are present.
Yes, I'm here on behalf of my senior,
Who is your senior?
Santosh Sharma. Madam.
It's outside counselor.
Okay. Question regarding the maintainability of this excise appeal is raised on behalf of the respondents. Stop. The net onset appearing for the applicant has submitted that since it's the question of since the question raised by the respondents regarding the maintainability of the application is a question of law, is ready to argue the same without filing any counter to the objection raised by the respondents. And it counsel appearing for the respondent takes some time on account of non-availability of the arguing counsel. When?
After 26 July, my lord. After 26 July, my lord.
26, this in the 19th of August.
No, sir.
Supplementary list item 41.
Met to your lordships. Yeah, 25. Lord, while taking the loan from the bank, I offered my two properties as a collateral security. One is the commercial building with 8 floors, consisting 8 floors. The other is my residential. As I failed to liquidate the loan, ultimately the bank approached the DRT. DRT has decided against me. Certificate has been issued. Recovery officer has been appointed. Recovery officer has also issued. Process normally should be 25, section 25, under which they will attest my property. Upon receiver, realize. That's how the prescription of law is. Now they have been issuing again the bank after even this, obtaining this certificate. Lordship may find this certificate for the moment at page 77. Page 77 is the notice issued by the certificate officer. Recovery officer. Recovery officer was appointed. Notice of demand was issued. This amount has been fixed. 14 crores 25 lakh 79,000. Just adding interest upon interest, they have gone up to this extent. While my loan was around 5 crores. 5 crores has gone up to this. Now, they have taken resort to the SURFACE Act and issuing me one after another notice that your property will be seized and sold out. Well, I have gone against one of those notices. The matter is still pending before the end. But then I am not against that also. I am ready that you may recover the property by following 25, section 25. The loan you can recover. The building which is larger, bigger building, which can yield you more money, you should go for that first. If you fail to exhaust the loan from therefrom, then you can come to my residential building. Lordship will kindly see. My residential building is smaller and it will not fetch that much of amount. But the bigger building actually will do. Rather, it will fetch much more. It is in the heart of the
Whether you
city.
can dictate such terms to the bank,
Sorry?
whether you can dictate such terms to the bank, both the properties are mortgaged with the bank,
Yes.
then that is their choice.
My lord,
That is
choice.
their choice.
My lord, this honorable
Which
court,
property they want to dispose it first.
my lord, normal proposition of law and a principle laid down by this honorable court
Yeah.
that there should not be disproportionate approach, discriminatory approach.
First of all,
And yes, ma'am.
first of all, we are not satisfied regarding the maintainability of the writ petition.
Yeah.
Since the Supreme Court has deprecated this practice in so many words from time to time, and recently in April 2024 also, wherein they were reminded the High Court not to entertain such petition because a complete mechanism is there and the person aggrieved should be asked to approach that authority.
My lord, I wholly agree with your lordship. I have seen that decision. The other day also lordship was referring to the decision. It is on your lordship's board. And I am on this decision itself. Lordship will kindly take up for a moment that decision.
Yes.
The apex court has said 2024.
Yeah.
2024, this is PHR Invent Educational Society.
Yes.
Yes, this is the case. Here, the decree was challenged, the order which was passed by the DRT was put into challenge, the High Court interfered with it. In that context, the court has said, I am not on that. My context is completely different. Even then, Lordship will kindly come to paragraph 29. Paragraph 29, I come within this. Paragraph 29, Lordship got it, my lord. Should I read it? Paragraph 29 of the judgment, 2024.
Could be thus clearly be seen.
Yes, it could thus clearly be seen that the court has carved out certain exceptions when a petition under Article 226 of the Constitution could be entertained. In spite of availability of an alternative remedy, some of them are thus. Now, where the statutory authority has not acted in accordance with the provisions of the enactment in question. So my first contention is Section 25 lays down how to go ahead. They have not done it. So infringement of the provisions of Section 25, this is a ground, Lordship may on that ground look into it. Secondly, it has acted in defiance of the fundamental principles of judicial procedure. Look, judicially, it has been laid down. The apex court has also said, I will come to that decision also, that when there are 2 or 3 properties, the authorities should first take the property which will fetch more money, which has the tendency to realize the entire amount. They cannot first take the smaller one and then go for the other one.
Yes.
That your lordship, I am on that. They should, if they take this property, the whole thing will be resolved there. Therefore, I am not challenging the decree or anything. My contention is that the procedure they have adopted is illegal. Otherwise, kindly see the decision to the. Well, in this case, apex court decision.
This, what, in context of paragraph number 29 to complete this.
Yes, paragraph number 29, this, I am on these 2 things. My lord, number 1, where the statutory authority has not acted in accordance with the provisions of the enactment in question, it has acted in defiance of the fundamental principles of judicial procedure. I will pass another decision also on this point. And it has resorted to, resorted to invoke the provisions which are repealed, and when an order has been passed in total violation of the principles of natural justice. I won't come 3 and 4. I'm on 1 and 2. Then 30, paragraph 30. It has, however, been
very important.
Sorry.
After observing this, the Supreme Court has clarified further the position.
Yes, my lord.
It is, however, been clarified.
Yes, that the High Court will not entertain a petition under Article 227 of the Constitution if an effective alternative remedy is available to the aggrieved person.
Or the
Or the
statute under
statute
complaint
under
has
which
been
the
taken
action.
itself contains a mechanism for redressal of grievance.
Yes. My lord, here.
Undisputedly, the present case was not so and so. We are therefore considered you so and so. While dismissing the writ petition, we have to remind the courts.
My lord,
Remind the
I have seen, my
following
lord.
words.
I have seen, my
Sir,
lord.
they are reminding us from time to time, and still you are
My lord,
insisting
it is in
that
the,
despite that reminder, we should interfere in these
my lord,
matters.
it is in the context. It is in the context.
It is unfair to us, sir.
My lord, no.
It is unfair.
My lord, in this context, in the context of this particular facts, the Supreme Court said that. And what was the position here?
Facts, yeah,
No, what
there's
was
a
the position
general
here, my lord? Kindly
observation.
see. Here, this situation was, instead of going on appeal,
Sir, Mr. Mehta, now you want that until and unless the Supreme Court slapped us, we should continue with
my
this.
lord, lordship has given the liberty to your lordship. That is my responsible submission.
That's liberty,
No
sir.
question at all. Kindly see.
Despite granting this
Well,
liberty,
we don't have
they have
alternative remedy.
issued a clarification. Don't do this.
Well, true,
Don't
but,
do this.
but at the same time, also carved out the situation when this honorable court can interfere.
Can interfere, but where the complete mechanism
No,
is there,
yeah,
don't
it is,
interfere.
that is, your lordship will kindly see whether we have that here.
Yes, you have that.
Here,
Section
whether we have
17,
that here.
you can very well, section 17, you can very well raise
My lord,
the objection.
my
which
lord,
is available
even,
to you.
even when such a notice was earlier issued, we have approached the DRT.
And that,
First to DRT,
that matter is pending.
that matter is pending before the
26th of August 2024, this order, next date is fixed.
next date is
Clear.
fixed. They have not, but they have not carried it. They have gone forward. The time has granted.
Moving further application, they another issue, they should notice. What else?
It is for judgment.
My lord, it is for judgment now, that case. They ought to have waited till then. They ought to have waited till then. But there is it.
97, page 96. Annexure 14. Page 96. The nature is better.
Yes.
So, my lord, firstly, when the issue is, similar issue is already pending, they ought not to have issued this notice and they should have fixed the date. Now, at any time, they can come and take my property. Whereas, it is open always, I am saying that you can first take my bigger property. This is the resident, I mean, the commercial building.
For 40 lakhs per annum. Right.
Wherefrom I get the rent of 40 lakhs per year. That is what is available to them. They could have by now in 2018 itself, attached that property, recovered many amounts from them by now. But they are not doing it. They are not doing it. Therefore, my responsible submission, when 25, kindly see for a moment section 25.
Yes.
After all, they have taken a certificate from the DRT.
Yes.
Now, once they have taken the certificate from DRT, they ought to have followed this and exhausted this. Then they could have come to any property I have. But they have not gone that way. They cannot arbitrarily act. Chapter 5, recovery of debt determined by tribunal. Section 25, Malad.
Surfacing.
DRT.
Recovery of debt.
Recovery of debt. DRT. Malad, in this book, section 25 at page 50 in my book. Recovery of debt determined by tribunal. The recovery officer shall, on receipt of the copy of the certificate under subsection 7 of section 19, proceed to recover the amount of debt specified in the certificate by one or more of the following modes, namely, attachment and sale of the movable or immovable property of the defendant, taking possession of property over which security interest is created, or any other property of the defendant and appointing receiver for such property and to sell the same, arrest of the defendant and his detention in prison, appointing a receiver for the management of the movable or immovable properties of the defendant, any other mode of recovery as may be prescribed by the central government. So, my lord, here, none of these procedures have been adopted till now. Recovery officer has issued the notice, thereafter it has not done. So this is an illegality committed. Therefore, the section 13 notice they have now issued, they do not have a choice to jump upon any of the properties, but to see it must proceed in such a manner that no undue hardship is caused. Their purpose is to realize the loan. If they get their loan money recovered, that's final.
Report has also said.
And for that, they should first go to that property, which will fetch them the amount.
Yes, more money.
Now, why then they are going for both at a time? Because there are other issues. Otherwise, this procedure, DRT procedure has been made redundant. Having taken recourse to a particular procedure and obtained the certificate, to get the fruit of that certificate, they should proceed in accordance with the procedure prescribed. That's my case. They have not done this. And otherwise, the matter is pending regarding that section 13 notice issued earlier. And regarding how the authorities should take the properties for attachment and sale, the apex court has meanwhile
This notice is under section 32, 13(2).
13(2). 13(2).
Where is that notice?
13(2) notice, my lord. No? Page 100, my lord.
Page 100.
Yes. This 98, my lord, is a very legible copy. Annexure 5, page 98.
198 and 100.
This was dated. This was dated 16/8/2022. And then again, 100 page, they have issued this latest one.
Latest one.
Latest one at page 100. It is 14/9/2023.
14/9/2023.
8/9/2023. I received it on 15/9/2023.
Okay,
Sorry,
14/9 and you
sorry,
received it on
sorry, my lord, just a minute. You know, 14/9, yes, 14/9/2020. I'm grateful, man. The top itself, it was mentioned. 14/9. They have mentioned this, and the final notice was issued on page 103. Page 103, fixing 11/7/2024 for taking physical possession. I'm against that. They have not come up now. In my civil submission, my lord, the cause of action for 13(2) has a long back evaporated because they have already approached the DRT. DRT has already decided the issue.
Yes.
So, my responsible submission is this is the procedural irregularity they have committed, and my recourse is only to 226. And Lordship's power has not been restrained by the apex court also, by that decision of the apex court. It has said that if there is a procedural irregularity, then 226 is available. But however, not by an appeal, like an appeal. In that case, the DRT decision was not challenged before the appellate court. They went to the High Court. Telangana High Court decided and passed the award passed by the certificate issued by the DRT. That's where, in that context, apex court said that no, this is not proper. Here, I do not have any alternative remedy.
Yes.
So, my Lordship may for the time being kindly consider even 13.2 that can be invoked whenever it is declared as what they call it banking term, NPA. Whenever the account is declared NPA,
Together new grounds.
immediately they can.
Raised at any point of time. Now you.
Sorry, no.
Every other point.
No, I am only placing it even to see how, whether it was proper on the part of the authority to invoke that to that extent. Even, my lord, because I am not assailing on these grounds, because I know that I am the loanee, I am to pay the loan. As soon I can get release of this, I'll be free. Now they are adding interest upon interest and they are escalating the amount. Whereas my property, that is why I'm saying that, well, you first take this property, this commercial property. Heart of the city in that Ganeshguri, this capital area. If they go for, they can recover it. Then why they are touching the other property, my residential property? That will create hardship to me. And in this context, Lordship is aware about that decision also. I'm just bringing it to your Lordship's notice.
Yes.
The decision in Bhixand True Alerts versus Samabai Dhanraj Google True Alerts. It is 2024 SSC online. Here, this is regarding execution of a decree. Execution of a decree in a process of execution, how to go about. Whether they will, which property they should first approach. The apex court has said. Kindly come to paragraph 25, 26, 27, I will place.
Yes.
25. It is thus settled principle of law that court's power to auction any property or part thereof is not just a discretion, but an obligation imposed on the court, and the sale held without examining the aspect and not in conformity with this mandatory requirement would be illegal and without jurisdiction. In the case at hand, the executing court did not discharge its duty to ascertain whether the sale of a part of the attached property would be sufficient to satisfy the decree. When the valuation of 3 attached properties is mentioned in the attachment Panchanama, it was the duty of the court to have satisfied itself on this aspect, and having failed to do so, the court has caused great injustice to the judgment debtor by auctioning his entire attached properties, causing huge loss to the judgment debtor and undue benefit to the auction procedure. The fact that the properties were sold for a sum of rupees so and so would further demonstrate that the decree holder would himself in the auction procedure has calculatedly offered a bid at rupees such and such, at a lesser price it was sold. 26. In view of the above discussion, we are satisfied that the present is a case where the decree is subsequently modified, varied, and the decretal amount was reduced from such and such to such and such. The sale of all the 3 attached properties was not at all required, and further, in the facts and circumstances of the case, variation of the decree rate together with the sale of the properties at a low price has caused huge loss to the judgment debtor, who restitution by setting aside the execution sale is the only remedy available. It is not a case where the restitution can be ordered appropriately or suitably by directing the decree holder to make payment of some additional amount to the judgment debtor to compensate him for the loss caused due to sale of his property. Doing so would perpetuate the injustice suffered by the judgment debtor. Then, in 25, instead of reading the entire thing, Lordship will kindly come to down below 27, paragraph 27, while discussing 144 CS CPC restitution. We will skip that. Next line from the bottom, my lord. The execution of a decree by sale of the entire immovable property of the judgment debtor is not to penalize him, but the same is provided to grant relief to the decree holder and to confer him the fruits of litigation. However, the right of a decree holder should to have bestowed upon him a bonanza only because he had obtained a decree for realization of a certain amount. A decree for realization of a sum in favor of the plaintiff should not amount to exploitation of the judgment debtor by selling his entire property. Here's my case is exactly the same. I have one commercial property, I have one residential property. This commercial property will go up to more than 14 crores. It's sold out. So that is available to them. They can go for without touching my smaller residential house. Therefore, my full submission, my lord, 226 is the only remedy available to me, and lordships will be pleased to entertain it and direct them that you first approach this. I have nothing to say. You first go for this property, try to realize it, see how much it comes. Then otherwise, all properties are available to them. I have stated that 40 lakhs per annum I am getting as a rent. I ask them that you appointed receiver, take this amount, adjust it, go ahead, so that my burden will be lesser. But they are not doing since 18. Things are not going in that proper way, my lord. They are in that particular field. Everything I cannot disclose here, but I do not have the specific. But one can gauge it.
Yes, sir.
That's why my response submission, my lord.
So now you want order on merit or?
Sorry, my lord, no, lordship will issue
Want
notice.
an order on merit or you want to avail alternate remedy?
Well, the
choice is yours.
my lord, in my response submission,
Choice is yours.
in my response submission, there is no alternative remedy at the moment against me.
At this moment, alternate remedy is already there. You can very well move an representation to the bank under section 13, 13(3)(a), capital A.
My lord, true. That is, of course, made, they are not listening because the case is pending before the DRT on the same petition. Judgment is, for judgment it is pending. They are
Sir,
proceeding.
you want order on merit? Certainly we are okay with that. He'll pass an order on merit. And taking into consideration the proceedings which are going on since 2014 for recovery of the dues and every attempt made by the loanee to delay that proceedings. We'll record all these things. Because
Malad, I don't think.
once you approach this court also for
Malad,
the very same, on the very same
True,
grounds.
Malad, no denial of the fact.
Non-suited you.
Malad,
There
why?
must be some end.
Why? I came before this court earlier only to find out some solution. And that failed ultimately.
Sir, if you have not find out any solution from last 10 years, then now.
Now only situation has arisen, Malad. Now only situation has arisen. And I am also not blocking it. I am not blocking them. I am saying, and Lordship will kindly see that part. They have to recover their money. I am agreeing that yes, you go and take it.
So since last 10 years, if we have not paid, then what?
That is why
rights are
ultimately,
there, sir?
Malad, that is why I ultimately, when my all endeavors failed, I had to forego with my property. I had to, because Malad, these are the company, the loan was in the name of the company. I was the director. And kindly see, Malad, the business is not going that way well. He suffered loss. Tried to revive. All attempt failed. Then ultimately, what is the when my all attempt failed to negotiate
8
even.
crores in 2014, 10 years have passed. Still it's very strange that the bank straightway without taking addition of the notice, issuing notices to you from time to time, issuing notices, physical position since 2014.
Malad, there were lot many
Like, sir, agar-
negotiations.
In place of this person, a poor farmer would be there, then they could have attached his property long back.
Malad, two things are there. One is Lordship is right. The second thing, this property is such valuable property that they are not getting an easy buyer. And they want to sell my smaller property, they will get an easy buyer, and with whom they are having nexus. That is another issue. Huh?
Yes, sir. Then
So my response submission, your lordships can, I am not asking that some interim order or anything. Lordship may say they may first proceed against my, that property, commercial property. Commercial property.
So now, sir, what do you want?
Sorry,
Order on merit or withdrawal with liberty to approach the appropriate authority, appropriate forum?
it will from, huh? Bank of India बोलेगा. Huh? Order made. Malad, my responsible submission would be that Lordship will be pleased to pass an order on merit.
Yeah.
And if your Lordship finds to in the interest of justice,
Yeah.
that some liberty can be granted, Lordship, it is, I leave it to your
Either
Lordship.
will grant the liberty on withdrawal, otherwise we are not.
No,
to
Malad,
grant any-
my instruction is to press it.
Okay, man.
Lordship will grant an order on merit.
This-
Because I mean, my responsible submission as I have placed it, the law also needs to be laid down so that where there
Law
in
is
future.
already clear, sir. Law is
That-
already clear.
Withdrawal will liberty.
This writ petition is filed by the.
Well, there is a little rethinking again. Instruction has come. So, Lordship may say, withdrawal would be liberty to approach the appropriate
Appropriate forum in accordance with law.
law. And also the appropriate authority to consider in accordance with law.
That is, they are
At the earliest,
They
my
are
lord.
obliged to consider if it is in accordance
No,
with
no,
law. We are not supposed to make
My
any
lord,
objection.
Lordship, it is presumed normally,
Suppose
they will do it in accordance with
tomorrow
law.
some instruction is coming from higher forum, that the High Court should entertain the petition and pass this. So where is the question? If petition
Lord,
is there, we have
Lord,
to pass an order.
I do not dispute it. Normally, the authorities have the obligation to do it, but at times they do
argue the
not
matter
do.
for quite some time. Learned counsel for the petitioner has submitted on instructions that he wants to withdraw this petitioner who seeks liberty for the petitioner to avail appropriate remedy available to it under the law. Dismiss with liberty as prayed for.
For hearing, item 36.
Deeply, at least for listening to my arguments.
Thank you. Yes, sir.
Yes, my lord. This is sixth schedule matter, my lord. What happened here, my lord? In the wake of the demand for autonomous state that started in late 70s, and there was a number of violent agitation also in Karbala and NCA districts. But in 1995, Government of India, Government of Assam, and the agitating parties.
Government of Assam is there?
Government of Assam, Government of India, Home Ministry, Chief Minister of Assam, and the agitating party. They signed a memorandum, my lord, agreeing to settlement on conditions subject to allotment of more departments to the Autonomous Council on the sixth schedule. Earlier, there were 15 departments, my lord, 15 more departments were to be allotted. And that has been already, my lord, I'll give your lordship the full, it is. Yeah. 95. Your lordship in that booklet, my lord. Hello, your lordship kindly come to page number 53 of that booklet, my lord.
53.
Yes, my lord.
Yes.
You will also have right hand side below, page number. Following that settlement, my lord, MEU, whereby the agitation stopped, the 1995 settlement, a resolution was passed in the Assam Legislative Assembly. Major lordship, but my lord. Page 53, my lord.
Referring to page?
Page 53, my lord. The page number you will find right hand side below, my lord.
Hmm.
Now your lordship will kindly come to next page. This resolution was adopted in the Assam Assembly, my lord. Then it was gazetted in on 14 July 1995, my lord. Next page. May I read, my lord? page 55. My lord, pursuant to the resolution adopted in the Assam Legislative Assembly on 12th of April 1995, and the memorandum of understanding reached between the Chief Minister of Assam and the Autonomous State Demand Committee, Karmi Students Union, North Coastal Students Federation, Dimasa, and Union, first of all, in New Delhi, in presence of the Honorable Home Minister, the Governor of Assam, in exercise of the powers conferred by Subpara 2 of Para 6 of the 6th schedule of the Constitution of India, the so 30 departments were allotted. Allot, transferred to the Karmi Angolan and sales primary Karmi Angolan District Council, not Autonomous Council.
Yes.
Then again, following that, in 1996, first 31st December, my lord, there was another resolution furthering the fulfillment of the demand of the party, my lord. Or also, Government of Assam has signed, the Chief Secretary has signed. There are certain other things, my lord, where it was stated there, my lord, in clause F, page 58. Here is also what, my lord, left hand side. Clause F, my lord, F. F for finance. The zonal heads of department from hills area shall be drawn by the state government. Officers in the rank of additional chief engineer PWD is equivalent in all the interested departments with the administrative, financial, and technical powers of the head of the department delegated by the state government shall be posted and placed under the administrative control of the Karbi Anglong Autonomous Council.
Yes.
The additional chief engineer PWD and its equivalent officers as mentioned above shall be posted within 31st of January 1997. During the interim period, the existing zonal heads of departments stationed in Karbi Anglong district shall be placed under the administrative control of the Karbi Anglong Autonomous Council. From here, some of them they have complied, my lord, some are left behind. What we want, very short prayer in our prayer is, let the government of Assam, and government of India has got one part, my lord, that is pending the parliament, 125th, my lord, resolution of the joint parliamentary committee, that has not been yet taken up in the parliament for final decision. Now, to raise the number of seats, delimited seats to from 26 to 50, and naming of the Karbi Anglong Autonomous Council with Karbi Anglong Autonomous Territorial Area. That is pending the parliament. That is under consideration, which the Chief Secretary and the Home Department of Government of India has said. That apart, now Chief Secretary has filed a video matter saying that we have complied in full. But
we have complied with.
In full, they have said.
Yeah.
But they have not done it. That's what. What I want, my lord, very short prayer is, let the government of Assam, government of India is only one agenda that they will do whenever the parliament considers it. Government of Assam fulfill in toto, like by letter speed, the 95 resolution, as that when the assembly, my lord, which was stated, allowing full function to the Karbi Anglong Autonomous Council of the on the 30 departments. That's all.
All right.
Pardon?
But here please read your prayer of
Yes.
the writ petition.
Yes.
Yes.
Yeah.
Mali, here department, you will also kindly come to page number.
The prayer part.
Yes, prayer part I am coming. Why I have sought cosment of certain things.
Page 23.
Yes, page 23.
Yeah.
Yes. In the premises aforesaid, your petitioner humbly prays that your lordship may be pleased to call for the record issue rule calling upon the respondent to show cause as to why read in the nature censored in mandamus or any other read order direction should not be issued, causing the impugn actions and the decision of the government and its department encouraging upon the allotted subject. Kindly mark my lord, allotted subject.
That
To
was
the-
the impugned action. Which are those impugned?
Yes, I have annexed. I'm showing that.
Which are those impugned actions?
Yes, I'm showing that.
Yeah.
Then further, my lord, further let me complete the prayer. And or directly commanding the state respondent to withdraw or recall any decision, including cabinet decision, notification which transgressed upon the elder subjects and further restrain them from interfering the legislative, executive and the order of the autonomous council of allotted subjects. And after hearing about so and so. Now you'll also kindly come to page number 73.
73.
Yes.
You first point out which
Yes.
are the impugned actions.
Yes,
of
page
the
73.
decision of the state government.
Yes.
Which have
The
violated
PW is Mali,
or whatever it may be.
PW is allotted subject to us.
73.
Yes.
Yes.
But the state authorities are exercising their power.
Sir, read 73.
It will go. Both central project will go.
Upgradation of road.
Yes. This is issued by the government of Assam. Otherwise, PW is fully allotted to the except national highways. Even the PMJ scheme it will be implemented by the Karbi Angle Autonomous Council matter. Centrally allotted fund. It will go. Next one.
This is one instance.
Yes, another instance, my lord, in education department. Primary and secondary, even formal education in college is allotted subject, are allotted subject. Now 75. Appointment of grade 3, 4 post minor teachers in education department is within the domain of the autonomous council.
Yes.
Yes, these two actions. Now we'll also come back to page 58.
These are the two actions.
Now one more,
One more.
page 58, NSSC.
58.
Yes,
Page.
page 58. Yes, this act was passed in the assembly, my lord, for appointment of grade 3 and 4 posts, but without any exception or exclusion of the autonomous scheduled areas where grade 3 and 4 posts are being directly recruited now by the government of Assam. Whereas it is the responsibility and within the periphery of the autonomous council. These are few of the instances, whichever
These are the three instances which you have pointed out.
yes, there may be more matter, but we have got hold of these things. Now we'll also kindly come to in that booklet, my lord,
Which booklet?
that I have given the Karbi Anglong.
Yeah.
Yes. You will also again, my lord, come back to page number 60.
Yeah.
Because there may be a question matter whether centrally sponsored scheme are to be either executed by the state government or the autonomous council. Clause M,
Yes.
all centrally sponsored schemes, central sector schemes, NEC schemes, externally added schemes, etc., in respect of the interested subjects, departments, for which fund will be released by the state government to the council as per sanction and released by the government of India to state government shall be implemented by the council as per the norms and guidelines of the government of India and communicated by the state government. That's what we want. We don't want anything beyond. There was also a matter that the autonomous council has the authority to enact law also, my lord. On the sixth schedule for administration of certain the territorial area of the council.
Example. Example.
22. Now they filed a reply. Have you filed any rejoinder to that, sir? They
Yeah.
clarified the position.
Yeah, they have clarified the position, my lord. They said we have complied.
No, they said
Yes.
that so far as regarding this class 3 and 4 posts are concerned, it is for the whole of state of Assam.
Yes.
And it doesn't cover this class 3 and 4 of the sixth schedule are not the areas, are not the post under the government of Assam, and posts under the sixth schedule area are automatically not covered by the Assam direct recruitment rules.
That should not come under the sixth schedule,
They have,
under 244 of the constitution area.
sir, they have mentioned it.
They have mentioned
This
by
is
the,
for the whole of the state of
but
Assam.
my lord, that's why in all,
Excluding
yes,
the post
yes,
that is there.
yes. No, one thing, my lord, in all enactments made by the government of Assam, six scheduled areas are excluded so far as the function of the
You
government.
can very well, you have the power to legislate your own laws for your
Yes, we,
areas. You can very well enact the law.
yes, we can enact the law.
Yeah.
And we are enacting.
Yes.
But this is a lot of sort of encouragement. So we want that the government of Assam should avoid doing that. That's all. And implement.
And so far as regarding this Mission Basundhara is concerned,
Yes.
they are saying it is not applicable in the hill areas. It is in respect
Now,
of. state
now
of
they have
other
said,
areas of Assam.
they have said in the code, of course. Yes.
And the other road is concerned, they said it is Pradhan Mantri Sadak Yojana. Union of India's scheme is there. They are directly monitoring it. State government has nothing to
But
do with.
But they are monitoring, but implementing agency as per the clause M should be the autonomous council.
The autonomous council, which is the implementing agency, is SRDA. What is this SRSDA? State Rural Road Development Agency.
Yes.
It is also an agency.
Agency. But
One
it,
thing
it,
also, my lord, I would like to point out as per my lord, page 58, my lord, recent act, my lord, some direct recruitment commission for analogous post in class 3 and class 4.
Yeah.
Act 2001. As per this act, my lord, one my lord recruitment process has already been over, and in that process, the autonomous council area has not been included.
Good.
That may be clarified by the my lord advocate representing the council. My lord. It is not included.
Remain there.
now that being clarified now, yeah, because it is all right. My lord, now only our demand is, our prayer is that, my lord, the 1995 agreement should be put in action.
So what they are assuring that we are doing it, then what remains to pass an order?
Yes, the lordship will know the benefit. They have already. And my lord, there are 2-3 departments where still they have not done it.
Which?
1995.
Which department?
Directory of Primary Secondary Education, government is operating.
Which one?
Director of Primary and Secondary Education. And DTO, District Transport Officer, has not been appointed yet.
You have not pleaded in the petition these things.
Yes.
Listen, and unless
I think we've
dispose
said
it
in
of that,
everything,
the government has assured, they will not consider, they will not approach over the areas. Okay.
Yes.
This
So, my lord, there, what they have said, my lord, that we noted, my lord, this was
considered, yeah.
finally. So, that will be because my lord, your lordship knows the long hesitation of
Still it is going on.
Which,
This Karbi Angle ensures the tribal legislation.
yeah, no doubt, sir. It is there, your rights are protected under the constitution.
Yes, under Article
Yeah, not-
244, my lord.
Sure. Okay. This,
Your lordship comes from, I think your lordship comes from fifth schedule area.
which one area?
Fifth schedule.
No,
You-
Rajasthan is not a beach.
No, I think tribal areas is there.
Tribal area in some of the area, that is Mewad and some,
Under
other area.
244, my lord, there are two schedules.
Yeah.
One fifth schedule in other states, but in northeast, Assam, Mizoram and my lord, Tripura, sixth schedule.
In Rajasthan, we are having some areas
Yes,
in this fifth schedule
yes.
and not my area. That is a,
No, I'm not about Lord's area.
that is Marwar, that is not.
Marwar, yes, I have gone, my lord. I've seen that.
This writ petition is filed by this PL petition is filed by the petitioner. Raising it. With a prayer to issue direction to the state government, the state of Assam and its department, not to encroach upon the allotted subjects of Karbi Anglong Autonomous Council, Karbi Anglong Autonomous Council, KAAC. Or commanding or directing the state of Assam and its department to withdraw, recall any decision, including cabinet decision notification, which transgressed upon the allotted subjects and further restrain them for interfering in the legislative and executive power of the KACC on allotted subjects. Full stop. Several instances have been pointed out in the writ petition to demonstrate that the state of Assam and its department are encroaching upon the allotted subjects of the KAC. Reply to the writ petition is filed on behalf of the respondent state, wherein it is clarified that the state government has not encroached over the allotted subjects of the KAC. And clarification is filed in respect of the actions taken by it from time to time, which as per the petitioners are the actions of encroaching over the rights of the KAC. Full stop. Learned counsel for the petitioner has submitted that from the reply of the state government, it appears that the state government has by and large not encroached over the allotted subjects of the KAC. However, there are instances where some attempts are being made which appears to be encroaching over the rights of the KAC. Full stop. At this stage, learned counsel for the state has submitted that as per the stand of the state government, the state government, as per the state government, the memorandum of settlement arrived at between the state government, KAC, and other stakeholders is to be honored, and the state government has not attempted to encroach over the allotted areas of the KAC till date and in future also is bound to honor the conditions of the memorandum of settlement.
1995, my lord.
The memorandum of settlement 1995
Yes.
in its full letter and spirit. Full stop. In view of the above submissions made. on behalf of the-
Just,
Concept-
sorry for interrupting, my lord. May I say, my lord, government of India has also filed the counter, my lord. They have said
Government had-
they filed. And they have said the government of India is considering the case.
Union of India.
Yes, Union.
Our stand is that regarding that inclusion of seats in the council and regarding transfer of
That
subject.
is matter is under consideration.
Yes, under consideration.
They may just note it.
Full letter spirit. So, the concept for the Union of India has also assured this court that so far as regarding the actions which are to be undertaken by the Union of India in terms of the memorandum of settlement dated, memorandum of settlement of 1995. The work is
2011.
2011, man. That is 2011.
2011, not 1995. The work, 2025, the process is going on and the central government shall take every possible steps to abide by the terms of the memorandum of settlement 2011. Yes. Stop. In view of the above submissions made on behalf of the parties, we are of the view that no further order is required to pass in this public interest petition. The same is therefore disposed of.
Obliged.
Thank you. नहीं नहीं किधर पर मेमोरेंडम कहाँ पे थे 2000 every page not 19 yes what are main Union of India 37 38
37 I am appearing on the other.
will take it now
Lots.
the day
Lots.
time is over. Take this. Thank you.